21 of 20, it was disposed of by your lordships. But the case was with a direction to dispose of the matter by the lower court. And
Is it
the
for correction?
Records were destroyed. Alipur, 13th Session District Judge, 14 July 2019.
Anyway, let it appear as to be mentioned.
All right.
Lordship, may I be permitted to mention?
Correction, yes.
Lordship,
To be
may I
mentioned.
permitted to
Lordship, record was not found. Second appeal 460 of 2016. It's after completion of paperwork and everything. It record was somehow missing from the department, and for a long time it is pending for hearing. So I am paying for the listing and or a fixed date.
Anyway,
as
to be
per-
mentioned.
To be mentioned.
Lordship,
Yes.
correction.
Correction.
Yes, Your Lordship, for extension of interim order.
Have you filed any application?
Yes,
For it?
Lordship.
Anyway, give it. It will appear under the heading application.
Lordship,
Yes, give it. Application for
Section 5.
copy served.
Very public mention for fixing further. Your lordship has been pleased to fix the matter, but your lordship at the bench of
Anyway, to be mentioned.
My lord, may I be permitted to mention one application for motor accident claim, my lord?
Application for
For stay application, my lord.
yes.
Lordship, item number 33 from today's list, Lordship. The interim order is expiring on 16th of April. If your Lordship could kindly take up the matter today anytime.
Okay, item 33. Okay, by 12:30, if it is not reached, you mention. If the matter is not reached by 12:30.
Similar in respect of item number 64, and the respondents are here. Your Lordship, kindly recollect, Your Lordship heard the second appeal at a length, and thereafter Your Lordship referred the matter to the mediation.
Yes.
And the mediation has not yet been commenced. But the interim order is expiring on Monday. Lordship, now other side is here. My Lord,
It is appearing in the list.
item number 64. Your Lordship can extend the interim order. He is appearing, my Lord, he is sole respondent.
Item 12:30. Item number
64.
Yes, item 64, record an order.
বলছি। And Your Lordship,
Learned advocates for the parties are present. As this matter is already referred to mediation and the mediation proceedings have not yet commenced, let this matter appear on. So when is the returnable date in that matter?
It was the 18th of March, it was returnable, but
Okay. Let this matter appear on 19/5/2026. The interim order granted earlier stands extended for a period of 8 weeks or till further orders, whichever is
only
earlier.
one thing, my Lord, kindly give some direction so that the mediation can be expedited, my Lord. Otherwise,
Expedited,
But,
extend
we have not
extend your cooperation. It will be
we have not
expedited.
received any notice as yet. So that, my Lord, the mediation, my Lord, register mediation, so that, my Lord, give some indication, I shall communicate that, my Lord.
Let a copy of this order be sent to the Secretary Mediation Committee for necessary steps. The communication shall be through the department as well as through the learned advocate.
Lord, he expedite the mediation. Lord, if you, Lord, should give some
Anyway.
indication, my Lord, otherwise it will, my Lord.
Those orders should not be passed.
No, my Lord.
Mere request is sufficient.
May I have your lordship's
Number 80, my lord, it was already been.
Item?
All the documents are.
One more instance, my Lord. Yes. Get the interim order for 12 weeks. So 8 weeks, my Lord, it will again come to, my Lord, in some time in vacation.
It means in the month of June.
May I have your lordship's kind leave, my lord, on a compelling and very urgent
Is
circumstances.
it original side?
Yes, my lord, I am.
Wait.
Lordship,
Just wait. Original side officers are not here probably.
Appearance.
Mentioned at 12:30.
But my lord, there is grave urgency. I cannot
No,
wait.
you cannot wait till 12:30.
My lord, because my lord, I want your lordship to list the execution application at 12:30. I do not
Very
have.
well, you mentioned at 12:30.
Very
The
well.
officers are not here.
urgent application for stay. File is here, execution.
Yes, give the slip.
Lordship, may I permit you to mention on? To be mentioned already, pursuant to direction, I have paid the deposit. Let it come under to be mentioned for confirmation.
No, let it appear under the heading application.
Another,
The other matter?
the other matter for confirmation of the payment.
Yes, as to be mentioned.
Lordship, may I permit you to mention one matter for inclusion?
Yes.
For inclusion.
Inclusion under what heading?
Lordship, this is application for inclusion CU 1265 of 2019. This is a long pending matter, Lordship.
No, we want under the heading application or hearing.
Hearing, Lordship.
Hearing, okay, after 2 weeks it will appear. Sub notice upon the other side.
Already served, Lordship.
Two applications are for inclusion in the list.
Yes, give it.
Rectifications.
Yes, hence this appeal, FMA 124 of 2024 stands dismissed. Judgment and award dated 16/8/2023 passed by learned additional district judge, first track second court Paschim Medinipur in MACC 612 of 2021 is affirmed. Anyway, the compensation amount may be withdrawn by the respondent's claimants.
From this court, my lord.
Yes, wherever it is deposited.
Oh, bless your Lordship.
Yes.
My lord, I'm for the appellate
just come
insurance
at mine.
company. I'll have to take instructions, my lord.
Well, my lord, may I just, I appear for the original respondent number 1 who has died in the meantime, my lord. I'm just praying for leave so that the legal heirs can take out an application for substitution.
Yes, record an order.
It is not necessary. Now he can file the application.
Let
Malad
that be
Supreme Court has said that either the respondent or the appellant may file the application process.
Let that much.
Learned advocates for the parties are present. As the sole respondent,
No, my lord, respondent number 1.
respondent number 1 has died. The matter stands adjourned for a period of 2 weeks to enable the parties to take necessary steps.
I'm grateful, my lord. I'm grateful.
Sir, item number 3, my lord, I'm for the respondent, my lord. My lord, there is a correction, my lord.
See correction.
Let me see what is the correction. Dekhi record ta dekhi item 3.
Lord, there is a typographical error. Order dated 27/11/2025. Last order. 27 November 2025. My lord, there is a typographical error in the name of the respondent, my lord. It should be Basiran BB instead of Basiran
The
BB.
cost title.
Yes, my lord.
Yes, record an order. Learned advocates for the parties are present. The matter is put up for necessary rectification in the cause title of order dated 27/11/2025. Stop. In the cause title of order dated 27/11/2025, the name of the respondent number 1 is recorded as Basiran Bini. It should be corrected as Basiran Bibi. Stop.
Grateful, my lord.
Let the rectification be made. Stop. Other contents of the order dated 27/11/2025 remain unaltered.
Grateful, my lord. BB.
For my lord, kindly fix a further date, my lord.
So matter is ready for hearing.
Ready for hearing, matter was fixed for argument, but my lord,
Fix a
your
date.
lordship was on.
Yes, record an order. Learned advocates for the parties are present. On the prayer of learned advocates, the matter stands adjourned till 6/5/2026.
6/5, my lord.
So the matter is to be heard out.
Matter to still.
Okay, 6/5.
6/5. At the hearing.
My lord, I am for the appellant. My lord, let the date be fixed for hearing. It is a case of 2007. Date may be fixed.
Yes, who is for the opposite? You are for the. Yes,
But
learned.
another thing, The name of the advocate should be deleted because Santosh Kumar Das has already expired 10 years
No,
ago.
in the order sheet, it will be
Now, in
rectified.
cause list also it was seen.
Yeah. Learned advocates for the parties are present.
Name should be deleted.
The name of the learned advocate for the appellant, Sri Santosh Kumar Das, be deleted as he is dead, and the name of the present advocate on record be substituted. As the matter is ready for hearing and the paper books filed, let this matter appear for hearing. দেখুন তো কবে আছে? এপ্রিলের 28-29। Okay, 4/5/2026. 4th May
5 result no?
at 10:30 a.m.
My lord, 4th readers were declared on
4th of May. It's Monday.
3rd May or 3rd হবে না তাহলে 6th করবে
5th। আচ্ছা, 4-এর জায়গায় ওটাকে 5 করে দিন।
1st May 5th May ঠিক
Six, my lord, I am for the appellant insurance company. My lord, this has been disposed of by Lok Adalat order 7 dated 7/4/2026. They have filed an application for substitution or something.
No, my lord. There is a typographical error, my lord, in the case number, my lord. It should be 2015, but it is 2025.
Typographical mistake in the number of the appeal.
Year of the
In order dated 7/4/2026. Learned advocate for the parties are present by order dated 7/4/2026. In the post title, the case number is mentioned as FMAT 325 of 2025. Let it be rectified and corrected as FMAT 325 of 2015. Item 8. Not today.
May please your lordship, that this matter was fixed at 12:30 p.m. yesterday, but your lordship did not take up this determination. It's the matter, my lord, which I was arguing, my lord, the point of my lord occupation charges.
Mr. Gupta is on
Mr. Gupta is on the other side.
Senior Mr. Gupta.
Lordship will fix any date or time, my lord, we'll come back.
Yes, learned advocates for the parties are present.
Lordship, I appear on behalf of the respondent. Lordship,
Shall I fix it on Monday?
Lordship may kindly fixes it on first week of May. Lordship, our client is out of station. We have to take up some instructions.
So Mr. Gupta will be available in the month of May.
Lordship.
Learned advocates for the parties are present. On the prayer of learned advocates, the matter is be fixed on 5.
Lordship may take it any other day, Lordship, 4th or 5th May, after 4th or 5th May.
Shall I keep it on 30th of April?
Lordship, our client is out of station. My learned senior had...
Okay, 6.
Well, it's 7th, my lord.
Okay, 7/5/2026 at 12 p.m. Stop. The interim order granted earlier.
Lordship,
Yes.
there was no interim order granted, Lordship.
No, there was an interim order. I filed an application
Yes,
for
the-
extension.
During
The
the
interim order granted earlier stands extended for a period of 6 weeks or till further orders, whichever is earlier.
Lordship will hear my submission. Lordship, the interim order had expired long
See,
back.
you don't have any objection to take a date after 1 month or 2 months. Only your objection is extension of interim order. This is your only objection.
Lordship, the interim order had expired.
Very well, very well. The court cannot take up the matter, so the court has to give some interim protection. This much has the court has to do. What can be done? The matter cannot be taken up. In the meantime, you give an undertaking that you will not execute the decree.
Lordship, this matter had passed in 2019, Lordship, and till now.
No. Question is, you see, suppose I don't extend the interim order. Tomorrow you execute the decree. So what will happen to this case?
Lordship, the next date before the lower court is on 19th of May. So Lordship will hear out the matter before that.
I shall try to dispose it prior to that, these applications.
Grateful, my lord.
Lordship will.
11, my lord, I am for the court. Appellant, my lord, yesterday it was fixed at 12 p.m.
12 noon. 12. Anyway, some other date has to be fixed. দেখুন এই মাসে কবে দেওয়া যায়?
Very short matter, my lord. Very short. How long? I have already completed my subject.
24 তারিখে কিছু ফিক্সড আছে দেখুন তো
27.
Yes, learned advocates for the parties are present. As the matter is ready for hearing and fixed earlier, let this matter appear.
Hard, my lord.
Let it appear on 27/4/2026 at 12 p.m. Okay, not today.
কারেকশন আছে কালকে এটা হয়েছে জজ সাহেব জাজমেন্ট দিয়ে দিয়েছিলেন এটা ছিলেন আপনি ছিলেন হ্যাঁ জাজমেন্ট
I did well, not today.
Milord, it was yesterday. Yesterday the judgment was delivered. Milord, perhaps there's a minor correction there.
গতকাল হয়েছে বৃহস্পতিবারে হয়েছে।
হ্যাঁ 8/4
জাস্ট এ মিনিট, এটা হয়েছে আপনার এই তো 7 তারিখে, এই 8 তারিখে হয়েছে।
8 April।
আচ্ছা
Lordship.
Record an order. Learned advocates for the parties are present.
আলমের নাম আছে।
In the instant matter, the date of delivering the judgment is mentioned as 4/4/2026. Stop. Let it be rectified and corrected as 8/4/2026. ঠিক আছে।
এটা সুচরিতার আছে, আমার মতো নেই এখানে। Lordship. Grateful to your lordship.
Instead of 4, it will be 8.
Yes,
my lord. Milord, 13, Milord, I was, Milord, humbly beseeching your lordship, Milord, to extend the date for depositing the check. Check is with me, Milord. Your lordship,
yes, record an order. Learned advocate for the appellant is present. It is submitted by learned advocate for the appellant that the compensation check could not be deposited within the time as directed by earlier order. Thus, the time to deposit the check stands extended till 16/4/2026.
Milord, in between, Milord, 4-5 days we are off, Milord. Your lordship.
2 days that is holiday. 14th and 15th it is holiday.
14th, Milord, even Monday, Milord, there is a confusion. Saturday, Sunday.
Monday is a working day, but many lawyers may not come.
Lordship. Milord, this order needs to be uploaded.
Honor stands extended till 17.
Lordship.
4/2026.
Lordship.
The check, the compensation check be deposited on or before 17/4/2026.
Lordship. Extremely grateful to my lord, Milord.
Yes, not today.
15. I'm for the responding.
In lordship, the matter has come at my instance, lordship. The
order was heard earlier.
No, lordship, the only issue is this future prospect that not awardable on a tribunal. Also 2 minutes time, 27th 1 p.m. can matter get disposed of. Only this is the issue.
So come with your written notes on the next day.
I have come with that calculation so that lordship will find I am not challenging the
yes, record an order.
Nothing. Only
learned advocates for the parties are present. As this matter is ready for hearing, let it appear on 27/4/2026 at 1 p.m.
Lordship.
27 তারিখ 1টার সময়। ঠিক আছে।
It- 16 and 17, my lord.
For the appellant insurance company, and my learned friend have also filed an appeal. And it is filed on the ground of quantum, can be disposed of, may be fixed on.
Go to Lok Adalat, it is on the ground of quantum.
No,
Oh, my lord.
My lord,
No.
earlier occasion, my lord, this matter was fixed 10:30 on 24th March 2026. My lord, matter already was fixed, my lord. My lord, on that day, my lord, my lordship not available, my lord, going to
There are other grounds
lord,
also, my lord.
Record and order, learned advocates for the parties are present. As the matter is ready for hearing and was fixed earlier, let it appear for hearing. দেখুন তো কবে আছে?
7th, my lord.
7th May, my lord.
7th May.
7/5/2026 at 10:30 AM.
Yes, my lord.
My lord, I'm grateful.
18 I am for the appellant lordship and 19th I am for the opposite address. Paper book is prepared.
At the point of law and the ground as taken by the insurance company, that is decided by the coordinate bench, by the appeal paper by the another lawyer. So issue is only is the quantum, subject to submission of the, because I have also the certificate copy where the issue has been decided. So the issue is means lordship, the pay and recover, that is the issue that has been decided. So only
That
issue
is
is the
regarding with
quantum,
other two matters.
others two matters. And lordship, I have filed as a cross objection, that is only issue the quantum. So but
Kindly
should the
fix
matter
the-
issue is the quantum. So on 28
the
at
date.
1 PM or 12:30.
Lordship, first week of May. will be better.
Abar first week of.
Okay, 30th of April.
30th.
Learned advocates for the parties are
Please,
present. Let this matter appear
Sorry,
on
voted
30th of
পরের দিন।
April 2026.
After release, just
3030
ভোটের পরের দিন
30 30th of April
গন্ডগোল
2026
হবে না
at 12:30 PM.
12:30.
ভোটে
হ্যাঁ,
গন্ডগোল
যে কোনো দুটো বেরি কেনা আছে।
গন্ডগোল হবে না
এটা 12:30 30 তারিখ।
হ্যাঁ 30 তারিখে আবার নাম দিতে হবে
এটা ও আচ্ছা সইটা হয়নি কালকে।
কিছু ছিল
আপনার কত বলো না আস্তে আস্তে নেন কোনো অসুবিধা নেই। 2 মিনিট 1 নম্বর হয়ে গেছে। এইটা 3 মিনিট ভার্সেস তখন
হ্যাঁ
কেন পুরাচ্ছ কেন মনে
My lord, 2021, my lord, insurance appeal with cross objection. Your lordship will fix it up a date, my lord, for hearing in the first week of May, whenever my lord pleases. My lord,
Yes, who is for the other side?
not my lord, friend is here, my lord.
Yes, learned advocates for the parties are present. As this matter is ready for hearing and the paper books filed, let this matter appear for hearing on 6/5
6th May. My lord, would it be my lord's pleasure to give a timing, my lord? Any time?
6/5/2026 at 12:30 PM.
12:30. Grateful to my lord, my lord.
My lord, I am for the appellate insurance company. Lordship, you are pleased to fix up the matter on 6th April. Lordship may kindly fix up any other date on May, my lord.
Yes, learned advocates for the parties are present. The learned advocate for the appellant is present.
Yes.
On the prayer of the learned advocate for the appellant, the matter be fixed on 6/5/2026 at 2 PM.
My lord, in this
Yes, I
this
did.
appeal, I am for the appellant, my lord. This is the workman's compensation appeal. My lord, disposed of appeal, only typographically error in the ordering position, the year. Kindly see.
Year of the claim case, my lord, it has been remanded back And the year of claim case has been typed wrongly.
Paragraph number 5.
Yes.
My lord, paragraph
Paragraph number 5.
Okay. The appeal is arising out of
Learned advocates. Oh, this division bench order.
My lord, it has been disposed of because this is
question
the
is how-
WC appeal, my lord. It was admitted and disposed of and remanded back. But
Very well. Now you see, this is not an order of a single bench. How the single bench will clarify?
the year,
only the year.
my lord.
Well, had it been passed by single bench, I could have rectified that.
My lord,
Or
only,
had the matter been come for hearing before me.
my lord, only this will.
But it would
is
not be
creating-
proper, you see. It would not be proper. It's better.
Only
Okay.
13 will be made into 2006, my lord. Nothing.
Otherwise, you do one thing. It's better you mention before the bench, which is the bench having determination to admit these matters.
My lord, this was admitted and disposed of.
My lord, this is the gazette notification, my lord, wherein the specifically written.
Say 2025 matter, okay.
Yes, it
This 2025 matter, did the single bench have any determination?
Yes.
But why it was placed before the division bench?
Because of admission, my lord.
Only admission portion before the
And
before the division bench.
bench has to be done, and thereafter it will
That
be.
means admission before the division bench means that is the bench having determination
My
to take
lord,
order
it
for
was
21.
admitted and disposed of, my lord. Kindly.
You see, just a minute. Had it been admitted, sent to some other single bench or before this court, I could have
It will
done.
not be admitted before any single bench. It will be admitted.
No. Suppose you see second appeal matters or this order 41 matters. Admission before the division bench. Hearing before the single bench. Okay. So the single bench has the power to hear and dispose. So the moment the single bench is disposing the matter, okay, the single bench will rectify or correct whatever it is. But once the division bench has disposed the matter, it is the division bench which is having the determination. So place it before the division bench having determination. Justice Bhattacharya's bench. Yes, learned advocates for the parties are present. As this matter was disposed by order dated 25/9/2025 by the Honorable Division Bench, the correction with regard to the claim case be placed before the Honorable Division Bench having determination in the matter.
I am grateful, my lord.
ঠিক আছে deeply obliged.
শুধু একটা দেখে একটা 18টা দেখে Milord, 24, Milord, we are trying to settle it out. Your Lordship will kindly fix up, Milord, any date after 18th, Milord. In between, Milord, we hope we will come back with the settlement order which before you. Milord, Lok Adalat is, Milord, on 9th of Milord, May or 13th of May. No?
I'm keeping it after 9.
No, my lord, kindly see, your lordship has been pleased to fix the matter on 20th, my lord, this 20th March at 10:30.
No, Mr. Singh is submitting that there is a chance of settlement.
Dispose of your lordship.
Milord,
Yes, under section 163A, no fault liability.
So I'll keep it in the month of May.
Milord, 18th, your Lordship will kindly fix. On that day, we will dispose it of.
18th of?
18th of Milord, April. 18th or 19th.
No,
2 minute লাগবে
2 minute লাগবে।
Application ही disposed of হয়ে যাবে। Paper book লাগবে না।
Okay, 20th April.
20th of April, Milord.
Yes, learned advocate.
Any time, Milord. It will
Parties
take
are
5
present.
minutes.
Let this matter appear on 20th of April 2026 at 4 p.m.
At 4 p.m, Milord. We will get it disposed of. Extremely grateful to your Lordship.
দিচ্ছে।
Yes, welcome. My lord, these appeals by the insurance company was taken up by your lordships in earlier occasions. And my lord, learned advocate for the appellate, my lord, submitted that the vehicle was implanted. And your lordship desire directing the insurance company whether that vehicle was insured just after the accident, the consecutive year on.
Some instructions.
Yes,
is to be
instruction as
obtained.
I had talked, my lord, with him, with her. My lord, her desire, let the matter be fixed 13. Or my lord,
13 means coming Monday.
coming Monday.
Okay. Learned advocates for the appellant, claimant is present. Let this matter appear on 13/4/2026 at 12 p.m.
আমি রেসপন্ডেন্ট এই যে নামটা নিয়ে নি এই
29, my lord, I am appearing on behalf of the appellants, my lord. Correction, my lord. 3 corrections are there, my lord. In the name of the order dated 11th December 2025, only one order has been passed. Dean. Yes, my lord. But after the name of the advocates, my lord, for the appellants, it's an insurance company. This is not an insurance company. I am appearing on behalf of the claimant, my lord. Claimant, my lord. And my lord, as well as my lord, the first paragraph of the order, my lord, appellants and insurance company. Insurance company should be deleted, my lord.
So
insurance
this is
company
not
not
an
appear.
insurance appeal.
No, this is preferred by the claimant.
No. Is it an insurance appeal? Claimant motor accident claim appeal?
Motor accident claim appeal, but not preferred by the insurance company.
Recorded order. Learned advocate
and my lord,
for the appellant claimants is present. The matter is put up for necessary rectification of order dated 11/12/2025 as the name of the advocate is wrongly recorded as appellant insurance company. Let it be rectified and made learned advocate for appellant stroke claimants. Other contents of the order dated 11/12/2025 remain unaltered.
my lord. In first paragraph, it is also written that learned advocate for the appellant stroke insurance company. That insurance company should be deleted, my lord. And my lord, the second paragraph, none appears for the respondent number 1 and 2. That is, my lord, one insurance, one is the car owner and 2 is the insurance company. And my lord, in that order, my lord, lordship directed to serve all the respondents through the department, my lord.
So, cause service to the department.
That service has been completed, my lord. My lord. In spite of that, my lord, none appears on behalf of the either of the party respondents, my lord.
Which is the insurance company? What is the name of the insurance company?
Insurance company. 1 second, my lord. New India Assurance Company Limited, my lord.
Yes, Mr. Singh, you appear for New India Assurance Company?
My lord, at times too, my lord.
So you take instructions in this matter?
Item?
I don't know, 29.
কে ছিল তে আগে তো কারেকশন আছে কেন
এই ইন্স্যুরেন্স কোম্পানি লিখে দিয়েছে ডিফারেন্স কেন বলতেই হবে
এটা আগে সার্ভিস করেননি ওদের
হ্যাঁ সার্ভিস করেছি ডিপার্টমেন্ট তো সার্ভিস হয়েছে service is on
Milord, let me get the papers from my learned friend, Milord. On the next day, I'll see to it somebody appears.
Just a minute. Let necessary rectification of order dated 11/12/2025 be made. It is submitted by learned advocate for the appellant that none appeared on behalf of the respondent insurance company in spite of service of notice. Mr. Singh is requested to look into this matter and take necessary instructions. Let this matter appear on
after 2 weeks, my lord.
Fix up a date, my lord.
23/4/2026. 23. Acha. 27/4/2026 under the same heading.
Okay, yes.
হ্যাঁ ওটা থাকবে
My lord, with regard to 27-28, my lord, I submitted that your lordship takes the matter after 13.
13th, on 13th I've kept it 12 p.m.
My lord, 13, my lord, she will be coming in the morning. The same, my lord.
So some other day.
Some other day, your lordship on 16, 17. বাবা 8 ঘন্টা লাগবে ঠিক আছে জজ সাহেব তুমি তো আর চালাচ্ছো না জজ সাহেব যেটা বলবে অন
এই 16 তারিখে কিছু আছে দেখুন তো
ইন্স্যুরেন্স কোম্পানি না দাঁড়িয়ে রিমান্ডে পাঠিয়ে দেবে ইন্স্যুরেন্স কোম্পানি
আরে 23-24 দেখো না
Okay, 28/4/2026 at 12 p.m. ওই অর্ডারটা একটু রেকটিফাই করে দেবেন ওই 27 আর 28
Your Lordship, I am appearing for the appellant.
So for the appellant,
Yes, Your Lordship.
what is this application can do?
I do not have any instruction, Your Lordship. The leading counsel.
Who is for the
I'm for the respondent interim.
Your Lordship,
paper books are ready?
The leading counsel paper books are ready. Service
Anyway, let it be taken up next week.
Your Lordship has already fixed a matter, separate matter on 4th May, a connected matter on 4th May at 10:30 a.m. If Your Lordship kindly fixes this at 10:30 a.m. as well on the
Yes,
same day.
which matter? What is the case number? Acha, learned advocates for the parties are present as this matter is ready for hearing and paper books filed. Let this matter appear on. Yes, Mr. Singh, shall I keep it on 4th May? Let this matter appear on 4th May 2026 at 12 p.m.
Lordship, I'm grateful to you, Lordship.
My lord, I am for the appellant in this case. I am filing the affidavit in service. My lord, in this case, it's a very small issue. The case was already awarded, but the applicant is 50 years of age and her whole amount has been kept in FD. So for that purpose, I have filed.
This is the appeal.
Appeal, my lord.
So the appeal, anybody has appealed?
No, I have talked to the East Coast Railway. So they are saying fix the matter. They will make the appearance. So it's a very small issue, my lord. Only for that thing, nothing else. Case was awarded.
Yes, learned advocate for the appellant is present. No, paper books filed.
Paper book I will file. It's ready.
Learned advocate for the appellant is present.
No, I will file. It's ready. I will file on next week day.
It is submitted by the learned advocate for the appellant that the paper books are ready. Does this matter be listed for hearing on 6/5/2026 at 10:30 a.m.
Lordship, Mr. Nag is appearing in this matter on behalf of IIT. He's engaged because of some personal difficulties. He's unable to.
Anyway, not today.
Lordship, no, in that case, kindly extend the interim order.
Interim order is there till which date?
Till 16th of April, Lordship.
So time is there.
Lordship, kindly give 3 weeks extension, Lordship.
Yes, record an order.
Lordship, in the second week of May, if it can be.
Learned advocates for the parties are present on the prayer of learned advocate for respondent number.
IIT.
Which respondent? IIT. 2.
Yes.
Lordship, Union and IIT are adopting each other's submissions, Your Lordship.
Learned advocates for the parties are present on the prayer of learned advocate for respondent number. IIT is for respondent number 2.
Yes, Lordship.
Respondent number 2, IIT authority. The matter stands adjourned till 7.
Lordship, respondent number 1 is also there. Union of India.
Your name will be recorded. 7/5/2026 at 2 p.m. The interim order granted earlier stands extended for a period of 6 weeks or till further orders, whichever is earlier.
Grateful, Lordship.
Yes, call the application. Applications. না না এখানে তো লেখা আছে যে আফটার টু বি মেনশন এটা হ্যাঁ আমি 10 মিনিট পরে উঠছি
My lord, very urgent application.
Yes.
I have a urgent application, stay application.
Yes, just stay application. Yes. No,
Item
no, the
number-
application is being called on.
Item number 49.
Item 49. Yes, yes, it will be called on. Yes, item 34.
Item 34 is insurer's appeal. The stay order has already been granted and the money is secured before your lordship's court. Today, your lordship will kindly issue directions for filing of paper book, informal paper book. And
yes, learned advocates for the parties are present. Huh?
And first time ekhane. Earlier it was before the honorable division bench.
So now it is ready for hearing.
Now it is ready for hearing.
This is 163 application.
As the matter is ready for hearing, as the matter is to be heard out, let informal paper books be filed within 3 weeks.
My learned friend would file the paper book.
By the learned advocate for the respondent. Let this matter appear after 3 weeks.
Lordship, can you fix the date? Under section 163A application, Lordship.
No, I am granting you 3 weeks time. That is 1st of May. Let this matter appear on 4/5/2023.
May. Grateful to your lordship. No, 4/5 তাড়াতাড়ি হয়ে যাবে দিদি পারবেন
আমি কাগজ দিলে পারবো
আচ্ছা 4/5/2026 at 12 p.m.
ওদিন ইলেকশন আছে
আচ্ছা 7/5/2026 at 12 p.m.
হ্যাঁ ঠিক 7th May. Grateful to your lordship.
Yes.
35 months. Lordship, in this matter, Lordship, Mr. Joyanta Banerjee appeared, Lordship, for the appellant, Lordship. Kindly, Lordship.
Any application to be taken up?
No, Lordship. Kindly, Lordship, let this matter appear, Lordship, on after 16th, Lordship.
After 16th of April?
April, Lordship.
Achha. Under the same heading, application?
Same heading, Lordship. Same heading, Lordship. Only, Lordship, section 5 application.
ও হবে না 20 তারিখ করে দিন ওটাকে
Much obliged, Lordship. Only, Lordship, section 5 application is here, Lordship. Much obliged.
Section 5 application is here in the record.
Yes, ma'am. Yes, yes.
So you are appearing for the other side.
Yes, yes.
So let it be disposed of. Why section 5 for section 5?
Lordship, file is not here with me, Lordship.
Let me see the record. Dekhi.
No.
You have a copy of section 5?
Yes.
Achha, dekhi section 5 application ta. What's the name?
Two applications are there.
One is section 5, the other is?
Other is correction of name of the name cost title.
How many days delay? Yes, record and order. Learned advocates for the parties are present. Are learned advocates on the application for condonation of delay under section 5 of the Limitation Act. Are learned advocates peruse the petition filed. Upon perusing the petition, it appears that the appellant petitioner has explained the delay for filing this appeal, which in view of this court is sufficient. Stop. Thus, delay in filing this appeal is condoned. The appeal is admitted and can 1 of 2024.
No admission. Matter is sent to the appropriate bench.
Oh, this is for the division bench.
Yes, yes.
Right. The section 5 is disposed. The matter be placed before the honorable division bench, having determination in the matter for the purpose of admission. Regarding rectification.
Lordship. You can too, Lordship.
No, this is only section 5. There is no other application. I don't find any other application.
Can two?
Oh, can 2. Can 2 is for rectification. Acha, the application can 2 of 2024 is taken up for consideration. The appellant has prayed for rectification of the name.
Paragraph 4.
Yes, name as stated in paragraph 4. The name of the appellant, which is the name of the appellant, which is marked as, which is recorded as CHHUTY Bagdi, be recorded as Simoti. Be recorded as Simoti be recorded as CHHUTIYA BAG TI or DI?
TI.
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 TI. The department shall carry out the rectification within 2 weeks. আচ্ছা ওই যে যেটা বলেছিলাম না, the matter be placed before the division bench, ওটা লাস্ট দিকে দিয়ে দিন. The matter be, after the amendments are carried out, the matter be placed before the honorable division bench, having determination in the matter for the purpose of admission.
Much.
Yes. Yes. Both applications are disposed.
Yes. 36 Lordship, I am for the appellant. So I prefer an appeal against the judgment of the tribunal only on the issue of quantum. But Lordship, the appeal is suffering with some delay.
Can one?
Delay, some delay. It's according to me, Lordship.
Section 5.
Yes, Lordship, there is a 64 days delay. Lordship, kindly condone the delay subject to submission of Mr. Bhomik.
Yes, what do you say? Yes, record an order. Learned advocates for the parties are present. Are learned advocates on the application for condonation of delay. Upon perusing the petition and upon hearing the learned advocates, this court is of the view that the appellant has explained the delay in preferring the appeal. Thus, delay in preferring this appeal is condoned. The appeal is admitted. Can 1 of 2024 stands disposed. As the respondent insurance company is represented, service of notice upon the respondent insurance company is dispensed with. Service be effected upon.
The owner did not contest, so
see, there may be so many problems. It's better you serve.
No, Lordship, it is the if they did not contest at the risk of the appellant, Lordship can dismiss. For the time being, Lordship can dismiss.
Okay, the service of notice upon respondent vehicle owner is dispensed with at this stage.
Lordship.
The trial court records we call for at the special messenger.
Special messenger court not required because of only the quantum is.
Otherwise, there will be delay.
Lordship, there is only the issue of quantum. I cannot develop my case by producing the lower road record.
Anyway,
only the usual Lordship can
the trial court records be called for at the special messenger cost of the respondents. Appellant. The paper books filed be kept with the record. Let this matter appear after 4 weeks.
And Lordship, the cost will be deposited by 2 weeks.
Just the trial court record be called for at the special messenger cost of the appellant to be deposited within 2 weeks.
Lordship, I'm depositing.
কত আছে পরেরটা দেখো
সেম
লিস্টটা তোমরা দেখলাম
okay, not today.
কত হবে তো আজকেটা কল করে দাও করতে কথা এটা কি আপনি কথা রেসপন্ডেন্ট লর্ডশিপ
This is your application.
Lordship, this is application for Lordship condonation of delay. Lordship, kindly condone the delay subject to submission of Mr. Singh.
How many days?
And lordship, their lordship 60.
628.
Yes, lordship. It's 628 days. Lordship, the award passed by learned tribunal not yet been satisfied by the insurance company, lordship. Also, I have annexed these papers also with the exception that I have filed the execution case also. That is also pending. Is it suffering with the?
Yes, record and order. Learned advocates for the parties are present. The application for condonation of delay is taken up for consideration. Our learned advocates for the parties produce the petition filed. The delay in preferring this appeal is 628 days. Stop. However, as the appellant has furnished grounds for condonation of delay, in the interest of justice, delay in preferring this appeal is condoned. The appeal is admitted. As the respondent, insurance company is represented.
Represent lordship.
Only you're for only one.
1 and 2.
1 and 2 both.
Lordship.
Respondent number 1 and 2 are represented. Service of notice upon respondent number 1 and 2 is dispensed with.
And C4 may be dispensed with.
However, at this stage, the service of notice upon the respondent number 3 and 4 vehicle owners are also dispensed with. The trial court records be called for at the special messenger cost of the appellant to be deposited within 2 weeks. The paper books filed be kept with the record. Let this matter appear after 4 weeks.
After 4 weeks, cannot date was followed. My lord is kind enough to fix up a date, Milord.
I have directed, let it appear after 4 weeks. If it does not appear, you mention.
Lots. What my lord, I am appearing for respondent number.
My lord, I am appearing for the applicant.
Appeal not maintainable, my lord.
My lord,
Lord,
this is-
can you see the impugned order?
My lord, may I place my case? My lord, I have come up with a very innocuous prayer, my lord. My lord, this is an MSCC appeal. My lord, we are not disputing the amount. We are only praying for some time so that we can pay the amount in installment.
I cannot take up this matter, okay? I was there in deputation in this
My lord, yes.
WBTC. Yes, record and order. Learned advocates for the parties are present. As I was posted in deputation before the West Bengal Transport Corporation, WBTC Limited, on deputation, the matter cannot be taken up by this bench. Stop. The matter stands released from this list. Let this matter be placed before the Honorable Chief Justice for necessary assignment.
Great.
It's no more attempt to
Milord, 42 is insurance appeal, Milord. Your lordship will kindly fix up a date for hearing of this case, Milord. Paper book, paper book.
Paper book, my lord. From the same judgment, my lord, another appeal is there, my lord. FMA 819 of 2025, my lord. Both the matters we had analogously, my lord.
When is the next date fixed with regard to that? Any date is fixed?
No. That is lying in the department.
Scan 2 is
Stay.
state petition, Milord. Your lordship will kindly dispose of this application.
And my lord, we have already prepared the paper book, my lord. And copy has been served upon Mr. Singh.
Scan 2 is your application.
Lordship will only kindly dispose it of, Milord.
Yes, record and order. Learned advocates for the parties are present. The application for stay filed by the appellant insurance company is taken up for consideration. You have deposited the entire amount.
My lord, it is
As
there,
the appellant insurance company has deposited the entire awarded sum, there shall be a stay of the judgment and award dated. দেখি record টা একটু বা পেপার বইটাও দিতে পারেন।
Yes, my lord. Paper book, my lord.
Judgment and award dated 18/2/2025 passed by learned passed by learned judge bench 5 City Civil Court Calcutta in MSC case number 308 of 2020 till disposal of this appeal.
Grateful to Lord.
The trial court records be called for at the special messenger cost of the appellants to be deposited within 2 weeks.
Informal paper book is ready, Milord.
The
Milord, special
informal
messenger,
paper book
Milord,
by
trial court record be called for in usual course, Milord, kindly, Milord.
ওটা special messenger cost-টাকে কেটে দিন।
Milord, then they will deposit the special messenger cost, respondent, at the cost of the respondent.
To be deposited by
the respondent.
The respondents. This FMA 819.
Yes, no.
819, my lord, this is, my lord, another appeal from the sales judge.
No, I am passing order not in this 819.
My lord is passing order in 1136.
Oh, I have just recorded this order, this judgment. এই যেটা আছে আজকে ওইটার পেপার বইটা দিন।
1136 এর পেপার বইটা
1136 এটা দিন।
একসাথেই করা আছে। My lord, all both the paper books has been prepared analogous.
No, 1136. Let me see that appeal, the judgment and award.
Milord, this paper book, Milord, is
the self-same award.
Yes.
আচ্ছা ঠিক আছে।
The same judgment.
আচ্ছা। Cause to be passed by to be deposited by the respondent claimants within 2 weeks.
Let this FMA 819 be tagged with this appeal.
No. Is it with regard to the self-same award?
Same award.
Acha, let
one appeal has been
FMA, let FMA 119
819 of 2025.
Let FMA 819 of 2025 be listed along with this appeal. The paper books file be kept with the record. Let this matter appear after 4 weeks.
Extremely grateful to your lordship.
Fix করে দিন না। ফিক্স করে আচ্ছা এনসিআরটা আসবে তো ঠিক আছে জমা করে দাও 15 টাকা ঠিক আছে করে দিচ্ছি
Obliged.
Lordship, this is act of cost title. Your Lordship, the respondent number 3 and 4 is a minor as no cost title cost title correct.
Before the local
daran na kuchi. The respondent number 3 and 4 is a minor. Inadvertently, the minor has not been mentioned. That we just want to incorporate that the respondent 3 and 4 is a minor.
They have not yet attained majority.
They have not attained majority yet. And this is as per to the lower court judgment as well. No, respondent number 3 and 4. Main appellate, memo of appellate, respondent number 3 and 4. Memo of appellate 3 and 4. Devasmita Devabhuta. Devasmita Devabhuta.
That is respondent number 3 and 4.
Respondent number 3 and 4.
So it is disposed.
Disposed of.
It is
3 and 4. That's it. Devasmita Ghosh and they were daughter of both the daughter of আমি দেখে লাগানো আছে সব আছে আমি যা চাইবেন
mother already dead.
Yes, where is the order of the Lok Adalat?
Your Lordship, the order is on the record, Your Lordship. Otherwise,
let me see.
আছে order copy আছে
Lok Adalat কপিটা দেখুন তো বার করে
ওখানে থাকবে ওখানে তো আছে আলাদা ফাইল থাকে
আলাদা থাকে
রেকর্ডের না থাকলে অর্ডার কি করে
এখানেই আছে এই জন্য দেখি তো টাকাটা ইয়ে হচ্ছিল তো উইথড্রল করতে গিয়েছেন
বলবার
লোক আদালতের অর্ডারটা
অনলাইনে আছে অনলাইন চেক কি করবে নেই
ওকে ডিসপোজাল অর্ডারটা হলো এটা
দেবী ঘোষ
দিন Yes, record an order. Learned advocates for the parties are present by order dated 13th December 2025, this appeal was disposed and settled by the Honorable Lok Adalat. However, as it is observed in the order that rupees 85 lakhs to the respondents be disbursed upon furnishing proper proof of identification and bank account details, but it is not mentioned that respondent number 3 and 4 are minors. However, it is clarified and clarified and ordered that the respondent number they are minor. Who will withdraw the check?
Mother.
Respondent number 1.
So number 1, Devi Ghosh. Yes, yes. Devi Ghosh will respond number 1.
Respondent number 1, Devi Ghosh, will withdraw the claim amount on behalf of the minor children, respondent number 3 and 4.
Yes.
Thereafter, the respondent number 1 shall take necessary steps as directed by the learned trial court.
And Lordship, the cost title to be amended as per accordingly.
The majority of respondent number 3 and 4 be
minority.
The minority of respondent number 3 and 4 be recorded, and the necessary rectification be made in the cost title by the department within 2 weeks.
Disposed this application.
Yes.
Application
No, you did not file any. Oh, one application you filed.
This is the application. Can 2 of 2026.
Can 2 of 2026 stands disposed.
Stands disposed of.
Grateful, Lordship.
Minute item, sir.
Yes.
Minute item 44, my lord, let it go out of list because the point involved in this appeal, my lord, is presently before in consideration before Honorable Supreme Court. For the present,
44, who is appearing? You are.
I am appealing for the appellant.
Item number 44.
Yes, my lord.
Learned advocates for the parties are present. As the matter is sub judice before the Honorable Supreme Court, let it go out of the list with liberty to mention.
My lord, the point of law involved, my lord, not the matter.
The point of law involved is sub judice before the Honorable Supreme Court. Let the matter go out of the list with liberty to mention.
Extremely grateful to your lordship. My lord, 45 is the extension of time to deposit the check.
45, yes, call 45.
My lord, the lordship will kindly grant me.
Learned advocates for the appellant
lordship
is present. It is submitted by the learned advocate for the appellant that the compensation check could not be submitted within the time as directed in the earlier order. Stop. Thus, the time to deposit the compensation check stands extended till 17/4/2026.
Extremely grateful.
Let the compensation check be deposited on or before 17/4/2026.
Extremely grateful to
46, my lord. My lord, item 46.
Taken in,
Last time.
matter taken in. Yes. 46 taken in.
Application for stay, my lord.
I appear to respond.
They filed a caveat. They are appearing, my lord. This is the 25,000 challan.
আচ্ছা এই সকালে ওই যে অ্যাপ্লিকেশন an order. Learned advocates for the parties are present. As the appellant's insurance company has deposited the statutory amount of rupees 25,000, there shall be ad interim order of stay of the judgment and award dated 20th December
2025.
2025 passed by learned additional district judge, first track, first court, Alipur, South 24 Parganas, in MSC case number 515 of 2019, shall remain stayed for a period of 5 weeks. The appellant insurance company shall deposit the entire awarded sum along with interest, less statutory deposit, as directed by the learned trial court within 5 weeks from the date of from today. In the event the entire awarded sum is deposited within 5 weeks, the interim order of stay shall continue till disposal of the appeal. The paper books, the trial court records we call for at the special messenger cost of the respondent number one to be deposited within 2 weeks. The paper books be prepared on arrival of the trial court records.
Informal paper.
The informal paper books be prepared on arrival of the trial court records. Liberty to mention after 4 weeks.
And my lord, the amount deposited may be fixed deposit, renewable fixed deposit.
Invested in a
Invested amount be invested in short-term deposit.
renewable short-term.
Renewable short-term deposit.
Milord, 47 is also interim stay. Milord, next matter, only this.
Okay. Yes, 47.
Milord, only interim stay. Milord, there is no condonation, Milord, no delay.
Same order, same order.
আরে ডেট এটা জজের নামটা ডেট
দেখি রেকর্ডটা। Learned advocate for the appellant is present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be ad interim order of stay of the judgment and award dated 22nd day of December 2025, passed by learned additional district judge, 4th court, Asansol, Paschim Bardhaman, in MSC case number 30 of 2016 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court, excluding the statutory amount within 5 weeks. Stop. In the event the entire awarded sum is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. The trial court records we call for at the special messenger cost of the appellant to be deposited within 2 weeks. The paper books be prepared on the informal paper books be prepared on the arrival of the trial court records. Service of notice to be effected in the meantime. Liberty to mention after 4 weeks.
Milord, amount be invested, Milord, and the LCR become in usual course, no special messenger cost. Other side is not here, Milord.
Yes.
Milord, investment order should be there.
Register general ওইটা ঢুকিয়ে দেবেন, হ্যাঁ?
And Milord, the LCR, Milord, be called for in usual course, Milord.
Special messenger cost I have given. Within 2 weeks.
Lordship. ঠিক আছে। God bless your lordship. I'm grateful.
আর দুটো ডেকে দিন এই 48, 49 টা।
48 lordship, my very unique was spared before your lordship, the appeal preferred by the insurance company. That is the only issue of quantum. The learned tribunal decided in 2018 6,000.
That means the matter is to be heard out.
Lordship, can you fix any date, whatever lordship died with permit?
দেখুন
Any date.
Yes, learned advocates for the parties are present. As this matter is ready for hearing and paper books filed. Let this matter appear on 30th April 2026 at 10:30 AM.
No, 10:30, 2 PM.
আচ্ছা 2 PM করে দিন।
And lordship, kindly record on that. I have filed one court. There is the number to COT 37
আচ্ছা, let this matter appear along with COT. Give the number.
37 to 2026, ঠিক আছে? 37 2026 সাল। Because that is in time.
Yes, my lord. You don't stay application, my lord. I have deposited statutory here.
Yes, record an order. Learned advocate for the appellant insurance company is present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be ad interim order of stay of the judgment and award dated 4th December 2025, passed by learned additional district judge, first track, first court, Tomluk, Purbo Medinipur, in MSC case number 480 of 2021 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court, excluding the statutory deposit within 5 weeks. Stop. In the event the entire awarded sum is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. The trial court records be called for at the special messenger cost of the appellant to be deposited within 2 weeks. The informal paper books be filed on arrival of the trial court records. Service of notice to be completed in the meantime. Liberty to mention after 4 weeks.
Investment.
Yes, incorporate that. Registrar General is requested to invest that amount. Yes, original site.
May I have my lords kindly mention a matter, my lord. This, your lordship had passed an order of 6th of March 2026, wherein your lordship had fixed the matter on 20th of March. Thereafter, your lordship had gone to the circuit bench.
Yes, just yes.
Thereafter, the matter was not taken up. It has not been in the list. I'm only praying for inclusion of the list.
No. What is to be done? It is to be clarified.
My lord, it has to be. It has to appear as to be mentioned, my lord. Kindly let it appear as to be mentioned because the matter was fixed on 20th of March. I mean, praying for inclusion.
To be mentioned on the next date.
17th, your lordship?
Probably not 17th, it may be 16th. Maybe
very
16th.
well, very well.
You know,
very well.
appearance.
My lord, may I have my lord's kind leave to mention one matter upon notice? My lord, by my lord's order of 20th February 2026, my lord directed my injunction petition to appear today. However, my lord, it's not in the list today. My lord, the interim order is expiring on 17th of April. And my lord, the appeal, my lord, 2 appeals were filed by the defendants, my lord, challenging the order of injunction. Those appeals are dismissed and my lord's order has not been interfered with.
Anyway, this matter will appear on 16th.
Great.
My lords.
Great.
My lords, I am appearing for the respondent.
Yes, it will appear on 16th.
My lords.
Yes. ওটা নোটিশ হয়েছে যে সাপ্লিমেন্ট আচ্ছা জাগে দরকার হয়নি ওই যে অর্ডারটা আছে অর্ডার
এটা কল করো রেগুলারটা করো
কল করুন সাপ্লিমেন্টারি লিস্ট
one indulgence.
clarification is required in this matter.
Yes, sir. I appear
According to us, there is
for
no
the
clarification required.
No, matter was referred to mediator, but no order that matter be the copy be sent to the secretary mediation committee.
As your lordship.
Record an order.
Before that, I appear.
That I'm opposite
I
to every
appear.
other syllable.
No, very well.
Yes.
I appear for the applicant. If lordship will kindly takes your lordship's operative portion
He was
of.
the applicant.
No, I have an applicant.
You're a degree holder.
No, I'm not for the decree holder.
Judgment debtor.
No, I'm not even for the judgment debtor. My lord, I am an occupant of the immovable property, which is the subject matter of.
Anyway, now that matter cannot be reopened. I've disposed.
No, I am not reopened. My lord, the lordship has kept the execution application pending.
Yes. That I've kept it.
My lord, may I say, my lord, lordship will kindly take page 24 of your lordship's judgment of 7th of April 2026.
Yes.
Lordship has appointed 2 special officers,
Yes.
my lord, to take physical possession of the suit premises.
Yes.
Now, my lord, I had an application under Order 21, Rule 97.
Yes.
Now, my lord, lordship has directed these special officers to take possession within 7 days.
Yes.
From 7th of April 2026. Now, that takes.
Whenever the special officer gets the copy of the order, he will take steps. Okay.
No, lordship has said within 7 days. My lord, the
7 days. He will affix a notice granting the judgment date opportunity to vacate within 7 days.
Yes, but the difficulty I say, my lord, I am in occupation. Now, my lord, I have a right of appeal from your lordship's judgment.
Very well, you do that.
My lord, I am
do that. This is
no, 1
absolute-
minute. My lord, I should not be interrupted. My lord, what I'm trying to, my lord, put across
When
is,
the matter was fixed on the date of judgment, you could have mentioned that to
my lord, I
stay
was
of the order.
yes, my lord, today, my lord, I am only. My lord,
At this stage, I cannot grant you any.
my lord, I appreciate what is falling.
My lord, I appear for the judgment data. My lord, I appear for the judgment data. My lord, will kindly permit me to appear virtually. My lord, the difficulty that I'm facing is, my lord, your lordships have passed an order. We have to oblige with your lordship's order. My lord, we are already taking out an appeal. My lord, your lordship knows the situation. My lord, coming week, my lord, till 15th, my lord, I have no remedy. My lord, there is already a proposed resolution on Monday. My lord, on 15th of April, I don't have a remedy.
Learned
My
advocates.
lord, kindly grants me, my lord, 1 week time. My lord, kindly will not put this order, my lord, to hold, my lord, for a period of 1 week.
Decree holder and learned advocate for an applicant in the execution case are present. The matter is put up for necessary clarification of judgment and order dated.
Your lordship is asking for the date of the
7th April 2026.
7/4/2026 in the said judgment and order.
That mediation issue your lordship wanted to clarify.
In the said judgment and order, although the mediator is appointed, but it is not mentioned that copy of the order be sent to Secretary Mediation Committee. Thus, a copy of order dated 7/4/2026 be sent to the Secretary Mediation Committee, High Court, Calcutta, for necessary steps. Such communication shall be made both by the learned advocates for the parties as well as by the department. A prayer is made on behalf of the judgment debtor as well as by the applicant, praying for some time so that necessary steps can be taken in accordance with law. In judgment and order dated 7/4/2026, it was observed that the learned special officer shall affix notice to vacate the suit property within 7 days. Stop. However, this period is extended.
But I'm opposing to this, Milord.
Although
January 25.
although it is opposed, this period to vacate the property is extended from 7 days to 10 days.
Milord, kindly makes it 14 days, Milord.
No, Milord, I'm
Milord, kindly see, Milord, from 7th of
15th, I do not have a remedy. My lord will kindly appreciate till 15th, I do not have a remedy.
From 7th, it takes us to 14th.
1 week is sufficient, as because they have prayed for, I have granted you 10 days.
Yeah, Milord, difficulty is, Milord.
Notice is not yet affixed, probably now.
Milord, lordships, Milord, penultimate paragraph of your lordship says that, Milord, they can take police help and they can throw me out. My lordship has given me 10 days, Milord. I'm extremely grateful for. Milord, just a minute, Mr. Banerjee. My lordship has granted 10 days, Milord. I'm only extending. I'm only praying for 14 days. Within that time, Milord, I will take steps to file the appeal.
10 days is sufficient.
Milord, 3 days, Milord.
Considers, my lord, it's an equitable ground, my lord. I cannot be left, my lord, remediless, my lord.
15th is a holiday. 15th is a holiday, my lord. Kindly.
Is the notice affixed?
Lord, I can't be left remediless, my lord.
We'll do
Lord,
it.
it's my staff.
We are on holiday.
The Basu's client is a nobody. So
No, very well. Then he is not entitled to execute the decree against me.
If it is affixed, okay. If it is affixed from the date of affixation,
yes,
you will be given 10 days time. So
the judgment debtor will be given 10 days.
Judgment debtor will be given 10 days.
I have similar prayers, my lord. Your lordship will consider,
He will go and say,
left remediless, my lord.
I am not even entitled to the benefit of those 10 days that your lordship has given. But I am only beseeching your lordship. Lordship has given 10 days, but kindly extended to 14 days.
There is no locus.
Because whether I have locus or not, Mr. Banerjee is no one to say that your lordship will adjudicate. But I have a statutory right.
4 days will not make a difference, but at least, my lord, my statutory right, my lord, cannot be taken, my lord.
10 days,
It's my statutory right to file an appeal.
Okay, 12 days I have granted you.
Very well. Deeply obliged.
Not considering.
My lord, Mr. Shomamo Ghosh is for the respondents due to some personal difficulty. He's not there in court today, my lord.
My lord, all I'm saying is, my lord, this is an application.
Next week, my lord.
Why this? No. Does this court has determination to hear this
Your
matter?
lordship's order. We are asking for recalling of your lordship's order. Kindly takes the master summons.
No. Let it be taken up in presence of Mr. Ghosh.
No, I am saying kindly allow me to say what I want. I don't think
This
Mr.
recalling
Ghosh-
application.
Yes, and I let them file an affidavit. I'm not seeking any orders as of now.
Anyway, he's praying for time on his.
But on what? I'm not saying only affidavits I'm asking for. What prejudice will it be caused?
Come up and submit, my lord.
But I don't understand, my lord.
Have the instruction. That is why.
Instruction to
Yes.
Is he accepting the application? He is not. I'm sure he will want to file an affidavit.
What is your instruction to seek an adjournment today?
Yes, my lord. Let it be.
Yes.
Taken up next
My lord, then one thing, let it be adjourned.
For the parties are present on behalf of learned senior counsel. Time is sought for. Such prayer is allowed. Let this matter appear on 16/4/2026.
No, then let it be 17th, my lord.
No, 17th. Probably this bench may not sit.
Then, my lord, let it be on the next week. My lord, I'm not there on 16th.
Then 24/4/2026.
But then let the defendant not take any steps in the meantime. Because that I'm not opposing his
What steps? No.
Because, my lord, after your lordship has granted the probate in their favor. Now, my lord, my letters of administration has been dismissed. Now they are trying to kindly see prayer B. All I'm saying, let them not do anything till the next day.
It is expected.
Yes.
It is expected that the parties will not take any steps in the meantime.
Yes, my lord. That's all I'm saying. Obliged to.
But there is a contempt application which has been filed before your lordship.
A review application is to be concluded today. From hearing, you see, on the last week, on the last occasion, you submitted at length. Now, anything else to submit? Thereafter, Mr. Cord will submit and conclude the matter.
I had submitted that. I was trying to rely on certain judgments.
Very well, you rely them and conclude the matter.
And in the so your lordship desires us to address the review application today, and with the contempt application can be taken up thereafter. Your lordship will then.
But in fact, technically, my lord, he has to, the contemners will have to purge, my lord, from the contempt first before they can insist on having the review application heard.
I had made that submission.
Contempt application I also have admitted and issued notice. They are before the court. Contempt application.
Yes, Lord, formal notice order was not.
Rule is not yet issued.
Rule is not yet.
But
issued.
notice order is notice is issued. Rule is not issued.
No,
notice. File applications, Lord,
that is why maintainability. After hearing the review, if I am not satisfied, the rule will be issued.
Very well.
But in fact, Millard, as a matter of submission, Millard, I must say that the fact that I have filed a review application prior in time to the filing of the contempt application, Millard, we have taken that as a ground. We have tried to, Millard, pursue our legal remedy. Be that as it may, Millard, as has fallen from your lordship, Millard, I have to satisfy your lordship on the ground of review. Millard, your lordship, Millard, will had passed this order. Your lordship will kindly come, Millard. I will not take much time. The order, Millard, under review is passed in GA 9 of 2025. And Millard, the order is dated 12th of December 2025. Your lordship, Millard, will find it that the order is, Millard, annexed with the memorandum of review. Millard, may I, Millard, very briefly bring it to your lordship's kind notice, Millard, very short background relating to this matter, Millard. Lordship, Millard, has passed an exhaustive judgment.
No, you see, with regard to the facts you have submitted on the earlier occasion.
Millard, I didn't. I couldn't, Millard, fully make my submission. I'll only make one humble submission. 3 applications were being heard by your lordship. GA 6, GA 9, and in between, Millard, GA 8.
Because GS7 was filed by a third party for an application in the nature of pro-interest issue that was disposed.
As you know, review is not an appeal.
No, very limited ground.
If there is an error apparent on the face of the record, this court can consider. I cannot go into the merits.
Yes. I'll be also relying on Lily Thomas because Mr. Chatterjee on the last occasion had said that he is also objecting to the maintainability aspect. I'll come to that. I'll cover all those points. But I want to begin with the aspect of merit. Your Lordship would appreciate that GA6 and GA9 were more or less, if not more or less, I would say similar applications.
You see, I shall not go into all these things. You show, first of all, where is the error apparent on the face of the record?
I'll come to that. Your Lordship, only one minute. GA8 was an application for maintainability. Our argument was, your Lordship, you
have taken this in your ground.
Yes, we have taken. I have taken. Our humble submission before your Lordship was that the ground of maintainability should be heard first. Based on that, and why we made this submission? Because we were relying on division bench order passed by this Honorable Court, which had said that preliminary issue has to be tested first. Coordinate bench order before your Lordship had taken up. And we had relied on a judgment passed by the Honorable Supreme Court. Here, comes the point of review, and why I say that, it is not, it is a mistake perhaps on the face of the records. This is my humble submission. Your Lordship sees your Lordship's order. Kindly have a look at internal page 36 of the order. And this is my sole ground of review.
Page 36.
Yes, the page number is at the bottom. Page 36 of the order under review.
Page
36.
Okay. Yes.
Your Lordship finds the judgment of Asma Latif. This is the judgment which we had relied on. However, with deepest respect, may I make this submission, we did not rely on paragraph 26. Our argument was, borrowing the principles laid down in Asma Latif, that the issue of maintainability should be taken up first. However, what has gone down, it perhaps could have been an error in typing as well. We have no hesitation to hold that Rule 10 is permissive in nature, enabling the trial court to exercise, in a given case, either of the two alternatives open to it, notwithstanding the alternative of the proceeding to pronounce judgment. The court still has an option not to pronounce judgment and to make such order in relation to the suit it considers fit. The verb shall in Rule 10, although substituted for the verb may by the Amendment Act of 1976, does not elevate the first alternative to the status of a mandatory provision. So much so that in every case where a party from whom a written statement is invited fails to file it, the court must pronounce the judgment against him. If that were the purport, the second alternative to which shall equally applies would be rendered odious. With deepest respect, paragraph 26, which is a part of this order under review, was not submitted by us because it deals with the provision of and consequence of filing or non-filing of written statement. That is not the case here. Here,
this decision was relied upon.
This decision, but this decision was relied upon, and a particular paragraph of this decision was relied upon. And with deepest respect, if we would have been a little more agile in telling your Lordship which paragraph it was, and further reminding your Lordship, perhaps your Lordship would have considered that. May I, once again hand up to your Lordship, Asma Latif's judgment for your Lordship's kind consideration. Kindly see, this is a judgment passed by the passed by Honorable 3 judges of the Honorable High Court, Supreme Court. Here, we relied on kindly see paragraph 52 onwards. And we had also filed our written notes specifying the paragraphs. So on the point of maintainability and a court not having jurisdiction. Here, the point of jurisdiction is the subject matter jurisdiction, because we say that subsequent events have happened. There is nothing left in the suit. That was our objection, main issues, my lord. My lord will kindly have a look at paragraph 49 first. Our issue, my lord, was that the suit has become a spent force. In GA8, that was our contention. My lord, may I place paragraph 49, my lord? What follows from a conspectus of all the aforesaid decisions is that jurisdiction is the entitlement of the civil court to embark upon an inquiry as to whether the cause has been brought before it by the appellant in a manner prescribed by law, and also whether a good cause for grant of relief claimed has been set up by him. As and when such entitlement is established, any subsequent error till delivery of judgment could be regarded as an error within jurisdiction. The inquiry as to whether the civil court is itself to entertain and try a suit has to be made by it keeping in mind the provisions in section 9 CPC and relevant enactment which, according to the objector, bars a suit. Needless to observe, the question of jurisdiction has to be determined in the commencement and not at the conclusion of the inquiry. This was, beloved, one of our bonal contentions. Although not directly arising in the present case, we also wish to observe that the question of jurisdiction would assume importance even at the stage a court considers the question of grant of interim relief. What interim relief is claimed in a suit before a civil court, and the party to be affected by grant of such relief or any other party to the suit raises a point of maintainability thereof, or that it is barred by law, and also contends on that basis that interim relief should not be granted. Grant of relief in whatever form, if at all, ought to be preceded by formation and recording of at least a prima facie satisfaction that the suit is maintainable or that it is not barred by law. Such a satisfaction resting on appreciation of the averments in the plaint, the application for interim relief, and the written objection thereto, as well as the relevant law that is cited in support of the objections, would be a part of the court's reasoning of a prima facie case, having been set up for interim relief. That the balance of convenience is in favor of the grant and non-grant would cause irreparable harm and prejudice. It would be inappropriate for a court to abstain from recording its prima facie satisfaction on the question of maintainability, yet proceed to grant protection pro tem on the assumption that the question of maintainability has to be decided as a preliminary issue under Order 14, Rule 2 CPC. Here, Miller Division Bench in our case had held, it has to be heard. That could amount to an improper exercise of power. If the court is of the opinion at the stage of hearing the application for interim relief that the suit is barred by law or is otherwise not maintainable, it cannot dismiss it without framing a preliminary issue after the written statement is filed, but can most certainly assign such opinion for refusing interim relief. However, this is most important. If an extraordinary situation, this is the defense which they can take. If an extraordinary situation arises where it could take time to decide the point of maintainability of the suit and not grant and non-grant of protection pro tem, pending such decision could lead to irreversible consequences, the court may proceed to make an appropriate order in the manner indicated above, justifying the course of action it adopts. In other words, such an order may be passed if at all required to avoid irreparable harm or injury or undue hardship to the party claiming the relief, and or to ensure that the proceedings are not rendered infructuous by reason of non-interference by the court. So, Millard,
yes.
Millard, these are the two paragraphs, essentially three paragraphs, which Millard, Mr. Shuman Kumar Dutt, learned senior advocate who was leading me in the matter, had placed before your lordship. But unfortunately, what has gone down, Millard, and what your lordship had considered was paragraph 26, which was completely on a different point.
So now you have relied 49 and 50.
Yes, my contention, Millard, is that I had originally also relied on 49, 50 and 51. Millard, now may I make this submission? Your lordship, Millard, has seen.
So this point is not considered by mistake.
I most
yes. Yes, what are the other errors?
No, only this.
So this is the error.
Only thing.
Very well.
May I make
It
one
ought to have been considered.
One more humble submission, Milord. One more.
So according to you, this page 36,
Milord, paragraph
this
26.
para 26 was not relied upon.
It should have been, Milord.
But this point was not placed.
My
this
humble
para
submission-
49 and 50.
49 and 50. Milord, one more humble submission, Milord. Your Lordship, Milord, has the entire records of GA6, GA8 and GA9. These were the three applications your Lordship was taking up. Milord, in GA6 and GA9, your Lordship will not find a single averment that there is an extraordinary circumstance for which an interlocutory application has to be heard and decided. Not a single averment stating what is the extraordinary situation which entitles the plaintiff to come over the rigors of Asma Latif. This is not there in GA6 as well, and not there in GA9 certainly. There is no pleading with respect to extraordinary situation. And Milord, extraordinary situation can be the only situation where the court would stretch its arms and grant the relief.
So two things you see. First, these two paragraphs were not relied upon, and the plaintiffs did not establish extraordinary circumstance.
No, did not plead.
Did not-
Establishment is the second, is
Okay,
stage 2.
Did not show any
Did not
extraordinary.
plead, did not show. Your Lordship can consider only those things which are pleaded, not anything else. So if there is nothing in the pleading, it cannot be, submissions cannot be made even with respect to that, because it's not pleaded. Now, Milord, with respect to the maintainability of the review petition, Milord, I wanted to cite two judgments because that can be a point taken by them, and I finish my submissions on it. Your Lordship,
Give a
Milord, will-
copy to your learned.
Yes, yes, I'm giving. Thank you. I have brought it. Lily Thomas.
Explain. একবারও আমার বলিসনি এটা।
একটু তো মাইলট কে দেবেন।
একবারও বলিসনি যেটা
Milord, I'm relying on the decision of the Honorable Supreme Court passed in Lily Thomas and others versus Union of India, reported in 2000 volume 6, Supreme Court cases, page 224. My Lord will directly come to paragraph 52. That is the only paragraph. It's the longest paragraph, my Lord, I would like to rely on. '52,
Yes.
Lord, that is your Lordship will find, my Lord, at page 247.
Yes.
52 is the paragraph at the bottom of the page. The dictionary meaning of the word review is the act of looking, offer something again with a view to correction or improvement. It cannot be denied that review is the creation of a statute. The court in Patel, Narshi, Thakaresh versus such and such held that the power of review is not an inherent power. It must be conferred by law, either specifically or by necessary implication. The review is also not an appeal in disguise. It cannot be denied that justice is a virtue which transcends all barriers, and the rules of procedures or technicalities of law cannot stand in the way of administration of justice. Law has to bend before justice. Next page. If the court finds that the error pointed out in the review petition was under a mistake and the earlier judgment would not have been passed but for erroneous assumption, which in fact did not exist, and its preparation shall result in a miscarriage of justice, nothing would preclude the court from rectifying the error. This court in S. Nagaraj versus State of Karnataka held, review literally and even judicially means re-examination. Well, I'm on this point. Re-examination or reconsideration. Basic philosophy inherent in it is the universal acceptance of human fallibility. Yet, in the realm of law, the courts and even the statutes lean strongly in favor of finality of decision legally and properly made. Exceptions, both statutorily and judicially, have been carved out to correct accidental mistakes or miscarriage of justice. Even when there was no statutory provision and no rules were framed by the highest court indicating the circumstances in which it could rectify its order, the court culled out such power to avoid abuse of process or miscarriage of justice. In Raja Prithvi Chand Lal Chaudhary versus Sukhraj Rai, this is judgment of 1941. The court observed that even though no rules has been framed permitting the highest court to review its order, yet it was available on the limited and narrow ground developed by the Privy Council and the House of Lords. The court approved the principle laid down by the Privy Council in Rajinder Narayan Rai versus Bijay Govind Singh that an order made by the court was final and could not be altered. Nevertheless, if by misprision in embodying the judgments, errors have been introduced, these courts possess by common law the same power which the courts of record and statute have of rectifying the mistakes which have crept in. The House of Lords exercises a similar power of rectifying mistakes made in drawing up its own judgments, and this court must possess the same authority. The Lords have, however, gone a step further and have corrected mistakes introduced through inadvertence. I'm on this, inadvertence in the details of judgments, or have supplied manifest defects in order to enable the decrees to be enforced, or have added explanatory matter, or have reconciled inconsistencies. Basis for exercise of the power was stated in the same decision as under. It is impossible to doubt that the indulgence extended in such cases is mainly owing to the natural desire prevailing to prevent intermediable injustice being done by a court of last resort, whereby some accident without any blame, the party has not been heard and an order has been inadvertently made, and if the party has been heard, rectification of an order thus stems from the fundamental principles that justice is above all. It is exercised to remove the error and not for disturbing finality. When the Constitution was framed, the substantive power to rectify or recall the order passed by the court was specifically empowered by Article 137 of the Constitution. Our Constitution makers, who have practical wisdom to visualize efficacy of such provision, expressly conferred the substantive power to review any judgment or order by Article 137 of the Constitution, and so on, The same, I'm just coming to the next placitum. In exercise of power under Order 40, in exercise of power under Order 40 has been framed, empowering this court to review an order in civil proceedings on grounds analogous to Order 47, Rule 1 of Civil Procedure Code. The expression "for any other sufficient reason" in the clause has been given an expanded meaning, and a decree or order passed under misapprehension of true state of circumstances has been held to be sufficient ground to exercise the power. Apart from Order 40, Rule 1 of the Supreme Court rules, this court has the inherent power to make such orders as may be necessary in the interest of justice or to prevent abuse of process. So, I was relying on paragraph 52. Also, paragraph 53 and even 54, these are all interesting reads. But your Lordship has found, that although the Supreme Court in this particular judgment was, may I make this submission? Although the Supreme Court in this particular judgment was essentially dealing with the power of review under the Supreme Court rules, but the Supreme Court, has brought it akin to Order 47. What my simple submission before your Lordship is that if your Lordship would have, considered paragraphs 49 and 50 instead of 26, maybe the outcome would have been different. Maybe your Lordship, then would have thought that wouldn't it not be wise to check whether there is an extraordinary circumstances pleaded in the interlocutory application or not. And your Lordship, in that course of inquiry, would have found that there is none. Because there is no extraordinary circumstances pleaded in writing by the plaintiffs in GA6 or GA9 and your lordship, my lord, has passed an order in GA9. The second thing which my lord perhaps would have triggered is that my GA8 was also being heard by your lordship, where I have taken a tangible point of maintainability.
You see,
my lord,
you just confine yourself with regard to the decisions where there is error apparent, the decisions which was not considered, if considered.
That is all. That is only one thing.
Okay,
only
that is one aspect, and the other is the sufficient pleadings was not there with regard to. So these are the two aspects where you find, or it may be found that there is error apparent on the face of the record. There is no question of which is maintainable or not.
No, I am not
this
asking
application.
your lordship, my lord, to revisit GA8 and pass an order in my favor.
Whatever
I am not asking that.
If there is error apparent on the face of the record regarding interpretation of the decisions or consideration of a particular paragraph or non-consideration,
my humble
very well, that is a ground for review.
One last submission which I, my lord, with your lordship's kind indulgence, if I may be permitted, my lord. I have shown from Asma Latif that any issue regarding maintainability, and even when an interlocutory application is being tested, that issue has
is that para 49 and 50.
That has to be heard first. So, this is a law which the Supreme Court lays down. If there is a mistake of fact, certainly it is a reviewable aspect. But if there is a mistake of law, the Honorable Supreme Court has also held that it's a reviewable aspect. Only one paragraph, from one judgment I want to show and then conclude my submissions. Netaji, BCCI versus Netaji. Sir. I'm relying on Board of Cricket Control for Cricket in India and another versus Netaji Cricket Club and others. It's reported in 2005, Volume 4, Supreme Court Cases, page 741. Lord will kindly take up paragraphs 89 and 90, which your lordship will find at page 764.
Yes.
May I place paragraph 89?
Yes.
Order 47, Rule 1 of the Code provides for filing an application for review. Such an application for review would be maintainable not only upon discovery of a new and important piece of evidence, or when there exists an error apparent on the face of the record, but also if the same is necessitated on account of some mistake or for any other sufficient reason. Next paragraph, paragraph 90. Thus, a mistake on the part of the court, which would include a mistake in the nature of the undertaking may also call for a review of the order. An application for review would also be maintainable if there exists sufficient reason thereof. What would constitute sufficient reason would depend on the facts and circumstances. The word sufficient reason in Order 47, Rule 1 of the Code are wide enough to include a misconception of fact or law by a court or even an advocate. So, my lord, I was on the terminology law, misconception of law. Because 49 and 50, my lord, in my most humble submission, my lord, is law laid down by the Honorable Supreme Court. Maintainability aspect has to be considered.
According to you, that those two paragraphs were not considered.
No, those two paragraphs were
while
not
deciding while coming into this decision, those paragraphs were not considered.
That is my humble submission, my lord, with deepest respect.
Yes, Mr. Kaur, will you continue at 2 p.m.?
Just give me 5 minutes. I'll conclude.
You want 5 minutes, or you want to come at 2 p.m.?
No, just 5 minutes.
Very well.
Lord, please take your lordship's order, Lord, which starts at page. Lord, just give me 1 minute. Kindly give me 1 minute. Kindly, will not see your lordship's order. Please come to internal page 4. Yes. Kindly, my lord, come to internal page 44 of your lordship's order.
Yes, 44.
Yes, 42, sorry, 42. 42 of your lordship's order, page 42 of your my lord's order. Kindly, my lord, come to the last paragraph at page 42.
Yes.
However, as the issue of maintainability, has your lordship got that?
Yes.
Of the suit is raised and there is direction by the Honorable Division Bench to decide the issue of maintainability of the suit first, and which is not varied by the Honorable Supreme Court, but only only liberty granted to the plaintiff to take out necessary application, the issue of maintainability has to be decided. Now, as the plaintiff, in terms of the liberty granted by the Honorable Supreme Court, has filed this instant application, and the issue of maintainability may require certain time to be decided, and which may also be taken before the higher forum on the decision, the defendant, although cannot be directed at this stage to pay the entire occupation charges due, but considering the fact that the day-to-day administration of Devottor estate is suffering due to dearth of fund and huge taxes are due and payable, and it is alleged that about 4 crores is due and payable by the defendant, it would be just and reasonable that for the benefit of the Devottor estate, sum of rupees 1 crore 50 lakhs be directed to be paid by the defendant to the plaintiff. This payment, however, will be without prejudice to the rights and contention of the parties. As a similar application is pending for occupational charges, it would be proper to dispose of this application with liberty to the parties to incorporate subsequent facts, if any, by the supplementary affidavit in the application GA number such and such. Now, my lord, this part of the order is exactly in terms of para 50 of Asma Latif. If your lordships kindly take Asma Latif. Kindly, my lord, come to para 50. This is 2024 4 SCC my learned friend has relied upon. Lord, please come to paragraph 50.
Yes.
It starts at page 717. Has your lordship got that? Please turn the page. Come to the next page. About 1, 2, 3, 4, 5, 6, 7, 8 lines from the bottom. Sentence starting with the word however. Has your lordship got that?
Yes.
If an extraordinary situation arises, has your lordship got that? Arises where it could take time to decide the point of maintainability. Lordships have really recorded that points of maintainability is going to take a little time. Maintainability of the suit and non-grant of protection pro tem pending such decision could lead to an irreversible consequences. The both the property will be absolutely they are in distress. The court may proceed to make an appropriate order in the manner indicated above, justifying the course of action it adopts. In other words, such an order may be passed if at all required to avoid irreparable harm or injury or undue hardship to party claiming the relief, and not to ensure that the proceedings are not rendered infructuous by reason of non-interference by the court. Now, my lord, how the DT is going to survive to contest the suit? Lord, kindly consider the extraordinary situation. May I just remind your lordship, 1 minute. There were several orders passed by the High Court entertaining the application, the interim application after filing of the suit, where, my lord, the court fixed the occupation charges that they have to pay. And this occupation charges was not being paid. This is the extraordinary situation. I didn't want to take your lordship through the judgment, but this has been noted by your lordship. This is the extraordinary situation your lordship wanted to protect. Court's order was being flouted with impunity. And the court had fixed the occupation charges that they had to pay. They did not pay. So, my lord, to balance the equities between the parties, this order was passed. Now, my lord, what they are trying to do, they are trying to re-argue their case. Asma Latif was duly considered. And, my lord, paragraph 50, this balance portion is reflected in your lordship's judgment, which starts at page 42, I had shown to your lordship. Now, my lord, this is one. Secondly is, Lord, what is the scope of a review application? Lord, all these two judgments that my learned friends have cited, Lord, principles are accepted. If there is a error apparent on the face of the record, but for that, Lord, no detailed argument is required. It's pinpointed that your Lordship's judgment, here there lies a mistake. That's a ground for review. Otherwise, it's an appealable order. And in the garb of appeal, a review can't be argued. Lord, this, your Lordships can take note of this judgment. This is 2021, volume 13 SCC, page 1. It takes care of all the judgments on review.
2021,
volume 13, SCC, page 1. Lord, your Lordships can take note of.
Have a copy?
I will.
No, not that.
No, just for the purpose of showing it to your Lordship, I'll give a copy, my Lord. During the recess, I'll make a copy and give it to your Lordship. Lord, two paragraphs I want to cite. One is 9.1. Come on, এটা কি হলো? So, ওদের kindly, my Lord, come to 9.1. Lord, all the judgments are discussed. I'm just quoting here from here. In Parsian Devi, so and so, para 7 to 9, it is observed and held as under. It is well settled that review proceedings have to be strictly confined to the ambit and scope of Order 47, Rule 1. In Tungabhadra Industries, this court opined, what, however, we are now concerned with is whether the statement in order dated such and such that the case did not involve any substantial question of law is an error apparent on the face of the record. The fact that on the earlier occasion court held on an identical state of facts that substantial question of law arose would not be per se conclusive, for the earlier order itself might be erroneous, similar event, etc. Then Lord, please come to 9.2. In State of West Bengal versus Kamal Sengupta, this court had occasion to consider what can be said to be mistake or error apparent on the face of the record. In paras 22 to 35, it is observed and held as under. 22, only kindly take note of the term mistake or error apparent by itself, very connotation signifies an error which is evident per se from the record of the case and does not require detailed examination, scrutiny and elucidation either of the facts or the legal position. If an error is not self-evident and detection thereof requires long debate and process of reasoning, it cannot be treated as an error apparent on the face of the record. To put it differently, an order or decision judgment cannot be corrected merely because erroneous, etc. But my learned friend assumes that your Lordships have not taken note of paragraph 49 and 50 of the Asma Latif judgment, which is reflected not directly in page 42 of your Lordship's judgment. The same reasoning are there. And Lord, here he wants to, Lord, argue on merit again that Asma Latif said that, Asma Latif said this. But Asma Latif also said that interim order can be passed. And this is, Lord, after 15 or 20 years after filing of the suit that maintainability has been raised. In between, the court has not only entertained the suit, but has passed several orders fixing occupation charges which they have to pay. They paid till December 2019 and thereafter stopped paying. And Lord, to balance the equity, your Lordship has passed that order. If they are aggrieved, Lord, this is a good ground for preferring an appeal. Lord, these are my submissions. This is not a case for review.
Yes, record an order.
Do you mind kindly give me an opportunity to come back on this judgment? Maybe after recess, I'll just take the time which is necessary to deal with this judgment.
I have only said that this is what the view of the Supreme Court, various judgments are.
Will come after recess.
Or Milord, even if your Lordship wants, Milord, I can come.
No, come after recess.
Hey, mention করব with the leave of Mr. Oh, তুমিও করো we
You
have
want to mention now or you want to come at 2 p.m.?
No, we want to do the matter if Lordship takes up the original.
I'll meet at 2 p.m.
Very well, Milord. We will wait, Milord.
My lord was pleased to direct us to provide a copy.
We were also carrying a copy for your lordship. It's very. Milord, your lordship will kindly take up, Milord, paragraph 9.2.
9.2 of the judgment relied by your learned friend.
Yes, well, learned senior colleague.
Yes, learned senior colleague.
9.1 and 9.2 are the two paragraphs which has been, Milord, relied upon by Mr. Call, learned senior advocate.
Yes.
I would, Milord, also place reliance on 9.2. If your lordship, Milord, is at page 20, 9.2, may I, Milord? Please. In such and such, the court had an occasion to consider what can be said to be mistake or error apparent on the face of record. And now, Milord, the quotation begins. The term mistake or error apparent by its very connotation signifies an error which is evident per se from the record of the case and does not require detailed examination, scrutiny, and elucidation either of the facts or the legal position. If an error is not self-evident, if an error is not self-evident and detection thereof requires long debate and process of reasoning, it cannot be treated as an error apparent on the face of records for the purpose of Order 47, Rule 1. To put it differently, an order or decision or judgment cannot be corrected merely because it is erroneous in law or on the ground that a different view could have been taken by the court or tribunal on a point of fact or law. In any case, while exercising the power of review, the court or tribunal concerned cannot sit in appeal over its judgment or decision. Milord, may I make this submission now? I anticipated that the question, Milord, would come up before your lordship, that a question of law is always a matter of appeal. Specifically, Milord, I have relied on a judgment of the Honorable Supreme Court, which predates this judgment, where it says that misconception of law is a reviewable point and not a point of appeal. Lily Thomas, Milord, very clearly explains what the proposition is. Lily Thomas is considered by this judgment of the Honorable Supreme Court as well. But, Milord, the aspect with respect to pleading, which has been, Milord, shown to your lordship's observation with respect to, Milord, the financial duress of the estate has been pointed out. Milord, your lordship has the records of GA9. I'm not going into that because the lordship has told me my scope is very limited. And certainly, Milord, I anticipate that when your lordship will be pronouncing a judgment on this review application, your lordship will have a scope to revisit the GA9 pleadings at least, because what is, Milord, been told is there is specific pleading with explaining the exceptional circumstance. Paragraph 50 of Asma Latif's case, Milord, talks about exceptional circumstance as the only exception. So your lordship, Milord, will try to find out whether there is pleading of exceptional circumstance in GA9 or not. This is not a case that I'm developing. I have, Milord, stated this in my written arguments. And if they have tried to explain exceptional circumstance in written arguments, that is not pleading. Why so? Because I do not get an opportunity to, Milord, through my affidavit in opposition, deal with that. That is contrary to fair play. Milord, in this court, I would not have, Milord, multiplied on judgments. But, Milord, I am constrained to show this authority to your lordship, Milord, which says that if in pleadings a point is not issued or is raised, of course I have to.
I'm extremely sorry to indicate.
They should
in
have,
reply.
They should have.
Question is, you are considering the decisions relied upon by your learned senior friend.
Yes.
Okay. So that
and also, Milord, the submissions made. In the submission made is that the issue of exceptional condition, extraordinary circumstances has been made out. I say not made out.
Very well.
And I say, Milord, it is not a part of pleadings. Anything which is beyond pleading cannot be considered. In this respect, Milord, I should be allowed
then
to.
It will continue indefinitely.
The question is, according to you, it is not made out.
Yes. Milord, your lordship has records of GA9. Your lordship will check that if something is not there, I cannot show it to your lordship. It's absentia. Kindly have a look at paragraph 26 once, and that's all. I had concluded my arguments. They should have, my lord, fairly told your lordship. It's not there.
26.
Yes, there's only one judgment. They copy that. Copy that. My lord, kindly have a look, my lord. Placidum D of paragraph 26 at page 657. Placidum D, paragraph 26. Your lordship has it, my lord. It is a settled principle of law that the parties to the suit cannot travel beyond the pleadings. So also the court cannot record any finding on the issues which are not part of pleadings. In other words, the court has to record the findings only on the issues which are part of the pleadings on which parties are contesting the case. Now, this is more important, my lord. Any finding recorded on an issue dehoors the pleadings is without jurisdiction. Such is the case here. I also say, my lord, it's a case here. When somebody is confidently saying, my lord, that there is exceptional circumstances made out in
if there are no exceptional circumstances, this point could have been taken in appeal. That would have been the better course.
No.
Grateful, my
lord. Lordship, kindly appreciate.
That would have been, scope would have been wide.
May I put it in this way, my lord? May I put it in this way? I face a problem from my father. I complain to my father. I don't go and complain to my grandfather. I have, my lord, faced a situation before your lordship. I have humbly come up before your lordship. And I have not criticized your lordship's order anywhere else. The appeal is a criticism of a lordship's order. I don't want to do that. Now, your lordship, my lord, should not hold that my hands are tied or I should be penalized because I have come before your lordship. Let us, my lord, approach the review application with an open mind.
These scope are much wider in appeal. Anyway, before the review,
I have relied on Lily Thomas and BCCI. Both says misconception of law is definitely, my lord, a reviewable point. Your lordship will consider that.
Okay.
And most importantly, when there is no pleading of exceptional circumstance, this should have been told to your lordship. The specific case taken by us. So, my lord,
that's all. Yes, record an order.
And I'm very grateful for a patient hearing.
Learned advocates for the parties are present. Hard learned advocates. Hearing on the review application is concluded. Fix 24/4/2026 for orders on the review application.
Now, my lord, so far as contempt is concerned,
after reply, there can.
My lord, there is no application for stay.
No,
there is no application for stay.
Is talking about
kindly allow me.
Anyway, I have fixed this matter on that day.
No, Judge, ঠিকই ভাবছে.
Let the application for contempt also.
We have filed 2 applications.
Kindly issue the rule. Let them come back before your lordship.
No.
Kindly issue the rule.
The application for contempt be listed on 24/4/2020.
My lord, kindly issue the rule. Let them come back before your lordship.
We have filed.
Let me decide this matter. Okay.
My lord, there is no application for stay for pendency of the review. So since they are not asking for any stay of the proceedings of the contempt.
Matter is before this court. Had it before the appeal court, okay. Then the question of appeal court staying the proceedings would have.
My lord, I really got amazed that my lord's order was never criticized before any other forum. And I really felt sorry to find out that my lord is being saddled by showing that these orders have got 39 errors.
Anyway, let me decide.
I really 39 errors in such a
will appear on the date fixed.
And my lord, we have filed 2 applications challenging the maintainability of the contempt application, which is already on record. They are not. They don't want to use any opposition to that.
Have copy? Yes.
My lord knows what is my instruction.
No, I don't.
I'm really.
It has to be expressed to the court. We cannot, my lord, in the bar exchange our pleasant.
Grateful, my lord.
I'm deeply obliged.
Yes, call the next.
Item number 3, content application.
For the petition. I'm for the respondent number 2. I am led by Mr. Arvind Mitra, senior advocate, my lord. He is not in court due to some personal reasons. I have been asked to file our evidence opposition. I have already served. Let me file the evidence opposition.
File the
number 2. Kindly fix the next Friday, my lord.
Why?
Mr. Mitra is not here, my lord.
My lord, I appear for respondent number 8, my lord. My lord, I was seeking an extension, a short extension of filing my opposition.
My lord, it is a contempt petition. Allegation is against the respondent number 2.
Mr. Mitra has been there throughout, my lord. Kindly fix
I am
Why regarding opposition, how many contemners are there?
One, the allegation, kindly look into the petition.
So contemner number 1 has filed the affidavit in
Two,
opposition.
two.
I'm the main
Allegation
person.
against is to contemner number 2.
So he has filed the affidavit in opposition.
Yes.
So there is no scope
Milord,
for
may I-
affidavit in
Milord,
opposition.
may I just say this?
What do you agree?
Milord,
The-
may I, yes, Milord.
the
May I
main
just 1
allegations
minute,
is against-
1 minute, Milord.
Milord, may I file the reply?
Yes.
Milord, respondent number 8, Milord, on the last occasion when we appeared, Milord, your lordship had given an opportunity for everyone who were appearing to file an affidavit, even taking the point of maintainability of this contempt proceedings, Milord. If your lordship takes your lordship's last order.
So let me hear out the matter. If necessary, I shall grant you an extension.
Yes, Milord. If
on the
that,
next day.
yes, Milord. That may be recorded, Milord.
Will not take time.
No, no.
Mr. Mitra is not here. I've been
on the next
I
day,
did not oppose this. I did not oppose my learned friend's prayer for fixing it on the next week, but I am opposing, my lord, the prayer of anybody else, my lord, seeking time to file affidavit.
No, question is upon hearing
yes
submissions on the next day, if necessary, I shall consider
Yes,
that
Milord.
extension.
Yes, grateful, Milord. That
Yes, learned advocates
17th
for
March,
the
17th.
petitioner and learned advocate for the contemners are present. Let the affidavit in opposition filed by respondent number 2 and affidavit in reply filed by the petitioner be kept with the record. Let this matter. Shall I fix it on 16th or 24th?
17th.
17th, this bench may not sit. So either 16th or 24th. 24th is Friday.
16th Thursday.
17th, this bench may not sit. That is why either 16th or 24th.
16th, my lord.
Milord, I am led by Mr. Bose, Milord. Mr. Bose may not be here, Milord. Kindly keeps it on 24th.
No,
that
I'm
much,
not
Milord.
opposing this.
Milord, that
opposing.
I am opposing.
17th, I'm not opposing.
16th, this bench may not sit. That is
16th.
why I am.
My lord, kindly keep it on 16th.
Milord, kindly
Let
some.
me 16th.
Milord,
Let this matter appear on 16/4/2026.
Milord, may my appearance be recorded at least, Milord. I'm not, Milord, I'm not the
Your name.
contemner. I'm not the contemner, Milord. Respond number 8, Milord. That
Very well, you give your name.
Yes. Yes.
At number 4.
Item number 4. Yes, none appears for the parties. The matter stands adjourned till 24/4/2026.
Number 5.
My lord, I appear for the defendant number 4 and 6.
So I'm appearing for plaintiff numbers 1C, 1D, and 1E.
Other defendant.
I think affidavits are already filed.
Already filed, my lord.
Also, may I file the affidavit in reply?
Anyway, the other side is not here. The other side is opposing you.
Defendant number 18.
So all the parties are not represented.
Mr. Ghulam Mustafa is appearing for the defendant number.
Yes, learned advocates for the applicant plaintiff and learned advocate for
Defendant number 4 and 6.
defendant number 4 and 6 are present. None appears for the other parties. However, in the interest of justice, the matter stands adjourned till 24/4/2026.
Great.
Let
Lordship,
the affidavit in reply file be kept with the record.
I'll deeply oblige.
On hearing at number 6.
But in this matter, I appear on behalf of the defendant number 36. Just
The applications, affidavits are all complete.
just give me 2 minutes time, Milord. Thereafter, Lordship will hear all the parties.
Yes.
But I suit for partition and declaration, Milord. An application, Milord, has been filed by some of the defendants, being the defendant number 1 and 2, taking the point that suit is not maintainable. Therefore, it is barred by law. Now, direction was given for filing the affidavits. There are about 38 or 40 defendants. Some of the defendants are companies and some of them are individuals.
Some have filed the affidavit.
Some have filed the affidavit.
Supporting the applicant.
And some companies, they have subsequently came in. Lordship might recall this matter. Lordship has heard it extensively. The point was,
I heard it extensively between the plaintiff and two of the defendants.
Lordship has heard the matter extensively
By the applicant, defendant, and plaintiff and the
applicant,
other defendant.
Mr. Mitro's client, who is the plaintiff, and the defendant number 36, my client, who is
after many defendants have filed.
Yes, the companies, they have come in, they say, though they did not file their written statement, but since they are parties to the suit, they have a right of audience and they would like to make their submission. At that juncture, my lord, in one of the companies where my client, the defendant number 36, is a director, we say that this company is saying that I have instruction to appear, and who has been authorized? Where is the authority? Because as director, I did not authorize that particular gentleman. Lordship will not call for an explanation, and that has been recorded in the order passed by your lordship earlier. Then finally, the explanation came, my lord, and they given an resolution to the effect that they have been authorized. But my lord, sum and substance of the case is whether the suit would be barred at the stage when Order 7 Rule 11 application has been filed, completely ignoring the averments made in the plaint or not. The law is well settled. Whatever is there in the plaint, that has to be taken as true and correct. Whether the suit is barred by Benami Transaction Act, whether the suit is barred, Lordship might recall, because there is a forum under the Companies Act where the NCLT court has any right to intervene or not. These points have been taken. And I and Mr. Mitro, my lord, we have extensively argued and met with all the points taken by Mr. Obrojit Mitro, my lord, who appeared on behalf of the applicants. So I would respectfully submit before your lordship. And my lord, there is an interim order to the extent in the suit that matter should not be transferred to the undefendant list. So the plaintiff, in other way, I am also, my lord, supporting the plaintiff's cause because it's a partition and declaratory suit, my lord. The matter can be heard with pending since 2011. And most importantly, this Order 7 Rule 11 application filed after a period of 12 years.
Now the submissions on behalf of the defendants who have filed affidavits can be heard.
But we have...
No.
Other defendants.
Some defendants.
Lordship would hear out everybody. I tell you, Lordship.
And Mr. Mitro, Mr. Obrojit Mitro, who has,
will have to give a reply.
Who has filed this application. Yes.
Let this come to an end. Initially,
for
13
years, Order 7 Rule 11 has been.
That will have to be considered at the time of taking decision on Order 7.
I tell you, Lordship, initially I joined issue on the right about the companies, whether they can come at this stage or not.
So that you have dealt it in your reply?
No.
Question
I filed an affidavit. I may not give up that.
No. Question is, you see, we are using an affidavit. Some have used the affidavit to support the applicant. Some has used the affidavit to oppose the applicant.
Yes.
So have you dealt with those affidavits?
But one affidavit I have filed, rest need not be gone into because it's a demurrer application. Order 7, Rule 11, plaint has to be seen only. There is no other way out. So I don't wish to file any reply. What reply I will file? Plaint and the documents. That's the law.
But the question is, you see, different persons, you see, the company's assets are to be partitioned.
Absolutely, that's the point.
Now the question is, up to this stage, company was not in the picture.
Yes, now the company.
Now the company has come into the picture.
The directors filed the application.
You see, Order 7, Rule 11, the plaint is to be seen. Absolutely. The nature of the suit is to be seen. Okay.
Companies have come in.
Up to this point of time, company was not in the picture.
Right. Now,
so many partition you are seeking, the companies have come into the picture.
Lordship, may I give you an example? Now the companies have come in. Lordship is absolutely right. The companies will take a stand. Whatever way, they will take a stand. But the stand cannot go beyond the averments made in the plaint at this stage.
That means in the affidavit, they have to say whether they are supporting.
Yes, that's all. That's all.
Cannot bring into new facts.
No. Nobody can. Nobody can.
Whether they're supporting the plaintiff or they're opposing. They want the plaintiff.
They are supporting the applicant.
Yes, or the plaintiff. Or the plaintiff. That's it.
Or opposing.
Or opposing.
So what is the ground?
Absolutely. And based on plaint. So why should I file an affidavit again? This will linger the issue.
So it's better let Mr. Bagh make his submission.
Yes, absolutely. I thought that I should give up other points, Mullah.
And the affidavit lordship direction was that I should file a reply to the filed by Bagh and the other.
If they have said something against you, against your maintainability, your suit's maintainability, you have a right to file an affidavit in reply.
I kindly, my lord,
Yes, yes.
on record.
Yes, yes, I'll record.
The
Yes,
affidavit filed by the
the
plaintiff.
affidavit in learned advocates for all the parties who are contesting this application, GA 11 of 2025 are present. Learned counsel for the plaintiff has used an affidavit in reply to the new applicants who have come.
Corporates.
New applicants who have come. Let the affidavits in reply be kept with the record. Yes, now make your submissions, my lord. Mr. Wagh.
Mr. Bagmal, I don't know whether he'll complete it today or not.
I may. No, let him start at least.
No, because after he completes, then Mr. Mitra has to give a reply.
Yes, that is at the end. But first of all, let him submit.
Let it progress, my lord. Roll
Yes.
Indeed.
He does not want the matter to go on. That is why he is anticipating that he will not complete.
After Mr. Bagmal,
Let me see your affidavit. What is it? You are
my affidavit. I will.
submission.
I
No,
also
no,
have an affidavit. My lord, I appear for the 10 companies your lordship has noted. My lord, after Mr. Bagh completes his submission, I also have an affidavit. My lord, I'll make.
Have you filed your affidavit?
Yes.
Yes, let him submit. You are appearing for which defendant?
Defendant number 3, my lord.
Hey, Deki, give his affidavit.
Before, my lord, I start, may I first indicate what is the plain case and why, my lord, the opposition.
Yes.
I'll come to my affidavit. That will be the answer, my lord. A summation to what I'm submitting now. My lord, may I first indicate a very important document, which is, my lord, a schedule to the amended plaint. Because the case which is made out is, my lord, a partition of the assets of a company. Without, my lord, really hearing the companies, this was sought to be moved. Your lordship will kindly take up page 69 of the amended plaint first, annexure E. And I'll very soon indicate, my lord, why I'm starting from here.
Yes. The affidavit of defendant number 10.
3, my lord.
Defendant number 3.
Defendant number 3. 10, my learned friends are, my lord, representing. Amadir hai.
Opposition to
Affidavit on
the affidavit in opposition to GA 11 of 2025 by defendant number 3.
Company, yes.
Yes.
But our affidavit is, my lord, formed on the 8th of January 2026.
Yes.
But before that, my lord, what I was indicating, your lordship will kindly take up from the plaint, page 69.
Your affidavit, page 69.
No, my lord. The plaint, page 69. Because I'll first indicate what the plaint case is.
GA 11, which page?
My lord, I'm showing from the plaint. It's basically the same, my lord. It's the schedule, annexure E, my lord. The schedule which I'm referring to.
E.
And I'll indicate from the plaint why, my lord, I'm referring to is because I'll quickly take your lordship to the amendments in the main plaint. And that's where my lord, grievance lies, and whether this can at all be maintainable under Order 7, Rule 11D. This really, my lord.
No, page, which page you are?
Page 69, my lord, of the amended plaint. If your lordship is pleased to take up the amended plaint separately.
No, is it here in this application, GA5?
Does Order 7, Rule 11, my lord?
Yes, this is Order 7, Rule 11.
Yes, my lord.
Which page of this Order 7, Rule 11?
My lord, it's not
annexed.
No, my lord, because this is a schedule of the plaint. The plaint is annexed. It is. এখানে আছে।
Yes.
Remember, this document is very important, page 69.
Yes.
Kindly see the assets. which are indicated here, my lord.
Yes.
Immovable properties is the head, Schedule 1. I'm not indicating in details, my lord. These are the officers indicated here. Residence, Hotel Stadel, land 1314, my lord, at page 71. Details are given. Then page 72 onwards, your lordship will find movable properties, basically bank accounts and jewelry, my lord, household goods, debentures, insurances, cars. That's page 76, my lord. And then Schedule 2 is AK group of companies. This I'll come. That's page 76, my lord. Page 77.
Yes.
Schedule 2. And the companies are, my lord, chronicled there. AK group of companies, 1 to 18. And then, my lord, page 20 is a continuation till 32 at page 83. Lordship has found that?
Yes.
Now, the reason why I'm referring to all this is, my lord, the amended plaint, which I need to, my lord, quickly rely on. Your lordship will find it starts from page 47. I'll show the amended portions, my lord. Your lordship will kindly take up internal page 13. After the 33rd, my lord, defendant, parties are added in the side.
Yes, 47.
My lord, total 35 and 38 parties.
Yes. Page 49 or 47?
Well, it's internal page 14.
14.
1-4.
Yes.
Lordship, I'll quickly take a lordship to the plaint case, which is made out. A brief history is given from paragraph 1 on late Arun Kumar Bhutoria, that they used to reside on a rented flat, and in view of this, they don't have adequate financial means. I'm at page 15, my lord. They're compelled to work right from the beginning. Paragraph 3, within a few years, started their own business, and how the business developed started in the name of AK Property Consultants, the last line of paragraph 3, my lord. Then from this, the income generated against this business, from this business, they took an office in rent in Park Street, and the business grew. How, my lord, the titles changed and the educational qualifications are not going into that. Paragraph 6, they wanted to work along with, my lord, the studies and how they developed the properties. Paragraph 7, 8, 9, 10, that they reside together in the premises. Your lordship will then take up internal page 18. So this is how the property is developing. 11A, my lord. Initially, late Arun Kumar Bhutoria purchased properties in his own name. Particulars of the properties purchased are as follows: ABC. Later on, Arun Kumar Bhutoria acquired properties through various companies floated by him. The shareholdings were under control of Arun Kumar Bhutoria, either directly or through his nominees or trustees. Very important, my lord. 12B, defendants 1, 2, and 38 held shares on behalf of Arun Kumar Bhutoria. All these persons were employed under Arun Kumar Bhutoria. Defendant number so-and-so holds shares of and in the defendant companies as trustee. Very important. Such shares were acquired with funds provided by late Arun Kumar Bhutoria and the AK group of companies. Particulars, including those held in defendant numbers 1 to 38, will appear from schedule annexed here to the letter A2. Now 12C, premises at 10 Pretoria Street is owned by a trust, namely Education and Welfare Trust. Refused to make over the trust deed or particulars of the present trustee to the trust. Plaintiff reserves the right. And then back to page 18, 11, 12, I'm not troubling your lordship. 12 is important, third line. AK Property Consultants extended and flourished and diversified activities in construction and commercial and residential. This is paragraph 12, page 18.
Yes.
Because of the hard work, sincere joint endeavor efforts made by the plaintiff's husband and plaintiffs, the business of AK Property Consultants extended and flourished, diversified activities in construction and commercial and residential buildings. From the funds accumulated out of the income of AK Property Consultants, diverse companies were promoted being, and the details are given, 3 to 34. Out of this, my lord, I am representing 3. And AK group of companies became a big name in the field of real estate. Assets and capital of the said companies being defined as 3 to 34 were purchased and or acquired from the income generated by the plaintiff and the plaintiff's husband by the business of AK Properties gradually became AK group of companies. So this is how, my lord, AK group of companies come into being according to them. Then multi-storied buildings, paragraph 13, the details are given. Multi-storied buildings, hotels, shopping malls, and details given. This I am not indicating. My lord, kindly take up paragraph 14 at page 20. In addition to, my lord, the aforesaid AK group of companies also undertook projects for and on behalf of several government and corporate clients, and the details are given, NBCC and the other companies, my lord. And then paragraph 15. This is, my lord, at page 21. Assets and capital of the state companies being defendants 3 to 34 were purchased and were acquired from income generated with the help of the plaintiff's husband by the AK Properties gradually became AK group of companies. Now paragraph 16 over the page, my lord. Defendant number 1 being the younger brother of the plaintiff's husband was unemployed and was idle. These are allegations, as was suffering from epilepsy bouts, so that he was not tense or depressed, and to settle him in future at the request and insistence of the plaintiff to her husband to engage defendant number 1 in some work at the office of so that the defendant number 1 can stand himself. The plaintiff's husband decided to employ defendant number 1 in AK group of companies. The plaintiff's husband also allowed one Sandeep Bhutoria, defendant number 2, to join AK group of companies to work with him. Plaintiff and the plaintiff's husband looked after and provided for each of the family members. Then paragraph 17. 1989 February, the plaintiff and her husband arranged the marriage of D1. Not really, these are. Then paragraph 18, 8 years younger, defendant number 1, 8 years younger to the plaintiff's husband, is being looked after by the plaintiff and her husband. Paragraph 19 now. During this period, may I only indicate previous paragraph, and was made, the first line at page 23, and was made to hold shares in AK group of companies for and on behalf of their minor sons, namely Jagrit Bhutoria and Rajat Bhutoria, respectively as trustee thereof till they complete their education and join business. I believe my learned friend is appearing for Jagrit Bhutoria. 19 now. During this period, in view of the fact that the plaintiff's children were very young and required more attention towards children, proper management, plaintiffs who participated in the business but devoted more time towards the family affairs at the request of the plaintiff's husband. However, plaintiff's husband used to have regular discussions with the plaintiff with regard to the business of AK group of companies in details, and the plaintiff always gave her advice and ideas so that AK group of companies can be extended and further flourished. Paragraph 20. With increase in family members, there was a necessity of a bigger residential accommodation. In search by the plaintiff and her husband, the premises number this, Pretoria Street, was acquired by the plaintiff and her husband. Funds came from income of the plaintiff's husband, over the page, 24. Page 24, my lord, the first line. The plaintiff's husband, the premises number 10 Pretoria Street is a huge bungalow with an outhouse. Plaintiff always wanted to live with her in-laws. Plaintiff and her husband requested her parent-in-laws to stay with them at premises this. And the parents-in-law, the defendant number 1, along with his wife and daughter, also started residing at the premises from October 1995. Though the shares in some of the companies were held in the name of defendant number 1 and 38, in reality and for all practical purposes, the same belonged to the plaintiff's husband, plaintiff and their 2 children. Both defendant numbers 1 and 2 worked as employees in AK Group of companies at all material times. AK Group was owned and belonged to the plaintiff's husband and the plaintiff. Paragraph 22. At all material times, D1 and the defendant number 2 did not have any right over any shares, over the shares of the said companies, and held the same as nominees and as trustee thereof for and on behalf of the 2 minor sons of the plaintiff, namely.
Could I have leave have ongoing matter before Justice Pattanagar 3 p.m. My junior is
Namely Jagrit Bhutoria and Rajit Bhutoria, who have now become major till their joining of the business. Despite the joining the business after demise of their father, the late defendant number 1 has continued to hold the said shares in his name. This is page 25, paragraph 23. Though the defendant number 1 was holding the shares in the said company, however, it was always understood and made clear between the parties that the defendant number 1 will not acquire any right, title, interest in AK Group of companies by virtue of such holding of shares in the name of D1. With an object to make the same clear, the defendant number 1 had also given a self-declaration inter alia, affirming the fact that AK Group of companies and at all material times absolutely belong to the plaintiff's late husband, and the defendant number 1 will not have any right, title, interest in AK Group of companies and business and or properties so purchased in the name of the said companies in any manner whatsoever, despite the fact that he would continue to render services to the group. Then paragraph 24, my lord. It is evident from the said declaration that the defendant number 1 is only a nominee of late Arun Kumar Bhutoria and held shares and remained in various companies and firms as mentioned in the schedule being annexure. Kindly mark this, my lord. Herein was formed out of the capital of the late Arun Kumar Bhutoria. And I pause here for a moment. This is why, my lord, I started with annexure E. And I'll come very shortly why. At page 26, the first line, the defendant numbers 1 and defendant number 38, 1, 2, and 38 have no right, title, interest on the said properties and or assets and or wealth and or anything of whatsoever nature of the said firms and companies as mentioned in the schedule being annexure E. So annexure E has those companies listed. All the companies which they say are under AK Group. So now I'll show, my lord, what they now start claiming. However, subsequently, this is paragraph 25, my lord. However, subsequently transpired that the defendant number 1 has started acting in detriment to the interest of the plaintiff's husband and claimed right, title, interest in properties and shares which belong to the plaintiff's husband. The plaintiff's husband was surprised and shocked to discover such wrongful and illegal activities on the part of the defendant number 1, and which resulted in severe mental agony and affected his health badly.
What is the nature of business of these companies?
They are in diverse business, mainly real estate, my lord. Mainly real estate. Mainly real estate, my lord.
These buildings are owned by the companies, these immovable properties.
By the companies, and now
companies, and these are the immovable properties of the companies, which, as per the plaintiffs, were brought out of the fund.
Indeed.
The business of the company is real estate business.
Different companies, different business, my lord. I'll have
So
to take
that
instructions for all the companies.
I think so far that premises is concerned,
My lord,
it is used as an office. Because there is no manufacturing.
No manufacturing.
Only used as an office.
Hotel business is there, my lord. So it's the Stadil is there.
Any hotel premises is made as a schedule of the suit?
Yes, my lord. Staddle, I had just indicated.
Hotel premises.
Hotel premises, my lord. And I'll come to that. I've shown in, my lord, that annexure. It's a 3-star hotel Staddle that's mentioned here in annexure. I'll come back to that, my lord. The plaintiff's husband. No. The plaintiff's husband was surprised and shocked to discover such wrongful and illegal activities on the part of the defendant number 1, and which resulted in severe mental agony and affected his mental health badly. He made his 2 sons join the business in March 2011. In October 2011, plaintiff's husband suddenly suffered a cardiac arrest and was taken to the clinic. Paragraph 28 over the page, my lord, page 27, the first line, paragraph 28, my lord. Husband of the plaintiff was free from ailments, no history of any problems, cardiac problems. Suddenly expired on October 2011. And then paragraph 29. The plaintiff's husband was, paragraph 29, my lord, was renowned and well-reputed person in the community, and in Kolkata, sudden death was shock. Paragraph 30. Upon demise, the attitude of defendant number 1 and wife, his wife towards the plaintiff, has become very hostile. Defendant number 1 has attempted to take control over all the assets and properties and business that have been left by the husband of the plaintiff, including AK Group of Companies. Kindly mark this, my lord. Assets and properties and businesses that have been left behind by the husband of the plaintiff, including AK Group of Companies. Paragraph 31. In the mourning period, when the plaintiff was shocked due to such sudden and untimely death of the husband, the grief, defendant number 1, clandestinely in collusion and conspiracy with defendant number 2 herein, removed all papers and documents relating to the properties and or assets. Plaintiff's husband, late Arun Kumar Bhutoria, and the plaintiff had not only set up various businesses or companies known as AK Group of Companies, but had also acquired ownership rights in several immovable properties, tenancy rights in several residential and commercial spaces, shares and debentures in various registered and unregistered companies and land. In addition, there are 2 assets of the deceased husband of the plaintiff comprises of investments made in fixed deposit, bank balances, cash, jewelry. Taking advantage, paragraph 32, my lord, taking advantage of the fact that the plaintiff is a widow and belongs to Bengali community, the defendant number 1 started distinguishing and identifying the plaintiff as a person coming from different community other than the Marwadi community to which the husband of the plaintiff belongs, and have gone to the extent of creating disturbances between her 2 sons and the plaintiff. The defendant number 1, acting under a hatched plan, have entered into a conspiracy with his wife, the defendant number 2 has also attempted to take control of the entire house. The plaintiff's son are very young, till today have not been acquainted with the harshness of realities, and paragraph 33, page 29. For the purpose of effective management of the records and books of accounts relating to all assets and properties, as also of the group companies, one of the offices of the plaintiff's husband, situated in Park Street, was being used for keeping, storing, maintaining the accounts, records, and documents of the group companies and properties. After the demise of the plaintiff's husband, the defendant number 1, taking advantage of the bereavement and mental state of the plaintiff consequent to the death of her husband, took control over all the accounts, records, and documents relating to the business and properties of AK Group of Companies, including personal files, bank account details, checkbooks, PAN cards, share certificates, details of demat accounts, and all connected documents and records, including statutory records of the companies. After the demise of the husband, the plaintiff had started attending the office of her late husband, but the defendant numbers 1 and 2, acting in collusion and conspiracy with each other, prevented the plaintiff to participate from day-to-day activities of the business set up by the plaintiff's husband. The defendant number 1 and the defendant number 2, over the page 30, instructed the office staff not to divulge any information to the plaintiff and to provide and or furnish documents and or particulars relating to the projects handled by the AK Group of Companies and the assets and properties belonging to the plaintiff's husband. Defendant number 2, at the behest of the defendant number 1, have even removed the personal documents of the plaintiff's husband and the plaintiff, including the checkbooks and other necessary documents such as balance sheets, income tax returns, and other files, are in custody of the defendant number 1 and are lying in the office of Park Street. The details given, my lord. The plaintiff has been deliberately ousted from taking part in the day-to-day administration of the said AK group of companies. Everywhere, my lord, this is the phrase used, AK group of companies, and have not been furnished with any details and or particulars despite repeated requests. The plaintiff has come to know from reliable sources that attempts have been made by the defendant number 1 acting in collusion with the defendant number 2 and his associates in trying to take full control of the assets of the plaintiff's husband to grab the entire assets, properties and shares of the plaintiff's husband. On repeated occasions, the plaintiff has requested D1 and D2 to provide details of immovable properties which the plaintiff's husband had belonging to AK group of companies. Plaintiff has also called upon the defendant numbers 1 and 2 to furnish details of all the immovable properties which the husband of the plaintiff had left. However, defendant number 1 has refused to divulge any such information. On the contrary, had sent a memorandum of understanding without any particulars and annexures to be signed by the plaintiff. Paragraph 37. In a surreptitious attempt to acquire and grab all the assets, now the build up to, my lord, why this partition, and a husband of the defendant number 1, even on the day of death of the plaintiff's husband, sent a letter to the share broking agent, details given, my lord, of the plaintiff, and also got a new email ID registered for the deceased husband of the plaintiff after his demise on October 2011, 14th October. All of a sudden, plaintiff came to know, paragraph 38, came to know of such letters written by defendant 1 from the communications received by the share broker, which came to the knowledge of the plaintiff in the month of April, May 2012. Immediately thereafter, caused reply to the said letters intimating the broker that at no point of time the plaintiff had asked to register a new email ID. In any event, question of changing the husband's email ID after his death does not and cannot arise at all. Plaintiff has come to know that the changes have occurred in the instance of defendant number 1 in this context, and the documents are annexed. Paragraph 39. Plaintiff repeatedly called upon defendant number 1 to furnish the details, enclosures, schedules which are mentioned in the memorandum of understanding. However, defendant number 1 refused to divulge any information. However, plaintiff has been able to gather a list of some of such properties, assets, and companies acquired by the plaintiff's husband, as informed to the plaintiff by her husband, particulars whereof would appear from schedules 1 and 2 collectively annexed hereto and marked with the letter E. Thereafter, now this is very, very important, my lord. I'll repeat this paragraph 40, kindly mark this. However, the plaintiff has been, paragraph 40. This is the build-up.
Paragraph 48.
40, my lord. First 40. Then I'll come to 40 and 40D.
Yes.
My lord, 40 once again, because this is, my lord, the pleading with regard to annexure E. However, the plaintiff has been able to gather a list of some of such properties, assets and companies acquired by plaintiff's husband, as informed to the plaintiff by her husband, particulars whereof would appear schedule 1, schedule 2, annexure E. That's what, my lord, I had referred to begin with. Now 40A and 40D. My lord, kindly take up page 33, capital A once. That's where, my lord, it is written. 33, capital A, my lord.
Yes.
After a page. Under the facts and circumstances, it shall be evident that the assets and properties mentioned in schedule E to the plaintiff belongs to late Arun Kumar Bhutoria. After his death, said assets and properties had devolved upon the plaintiff and the defendant numbers 35 to 37, having 1/4 share each. 40B. The plaintiff states that some of the assets and properties were in the name of late Arun Kumar Bhutoria, including shares which were standing in his name in several of these companies which were owned by him. Touches upon exactly on the company shares, my lord. However, some of the properties and shares which have been described in Schedule E were standing in the names of defendants 1, 2, and 38, and they are holding the share same as trustee for the benefit of the heirs of late Arun Kumar Bhutoria. Defendant numbers 1, 2, and 38 were at all material times standing as in a fiduciary capacity by reason of relationship of confidence enjoyed by the defendant numbers 1, 2, and 38. In so far as late Arun Kumar Bhutoria was concerned, the properties which were in the name of defendant numbers 1, 2, and 38 are all impressed with constructive trusts and are held for the benefit of heirs of late Arun Kumar Bhutoria. I need at least 2 more things. 40C now. The plaintiff states that several of the properties are standing in the names of defendant numbers 3 to 34. The shares of and in the said defendant numbers 3 to 34 were almost to the entirety held by late Arun Kumar Bhutoria. Defendant numbers 1, 2, and 38, and by way of cross-holding between the defendant numbers 3 to 34. The particulars of shareholding of the defendant numbers 3 to 34 will appear from a schedule annexed hereto and marked A2. The aforesaid manner of cross-holding of shares is evidence of the fact that the defendant numbers 3 to 34 were in control of the late Arun Kumar Bhutoria, and the persons who are holding shares of such companies in trust and for the benefit of late Arun Kumar Bhutoria, and after his death for his heirs. Several immovable properties standing in the name of defendants 3 to 34 have all been given in the schedule E to the plaintiff. Lord, I pause here for a moment. Lord, you will kindly mark this. Several immovable properties standing in the name of D3 to D34, that's the companies. This is very important, Lord, because this is the crux of what I'm going to argue. So they have admitted in the their plain case that these properties are standing in the name of these companies. Incorporation of defendant numbers 3 to 34 were only to have a corporate will, whereas the true beneficiaries of the immovable properties was of late Arun Kumar Bhutoria, and after his death they stand for benefit of his heirs. Now 40D. In view of the aforesaid, the plaintiff has claimed rights to the extent of a 1/4 share in the said properties. In any event, and in the alternative, the plaintiff is entitled to claims 1/4 right in respect of the equity shares of and in the said defendant numbers 3 to 34, particulars whereof have been given in the aforesaid schedule annexed and marked as A2. I'll come back to that. Lordship will kindly come back to page 33.
Yes.
My Lord, would it be your Lordship's pleasure if I stop here and continue on the next day? Because I am, my Lord, I'm being told and directed by my learned friend that the next matter is his. So he at least wants the next matter to be called once.
Next matter means different case.
Different
No,
case.
not completely different. Okay.
That's the reason, my Lord.
Oh, you are not in
This matter,
matter.
he is already there. So, my Lord, this matter is covered. Now, the next matter, my Lord, he wants to be called.
Different companies, same director.
No, not in this matter. In this matter, my Lord, I'm only.
Although he is appearing in this matter,
This
but
matter is done.
has
So he wants the
another
next matter to be called, my Lord.
Anyway, you will not be able to conclude today.
I won't, my Lord.
Let us
I'll take
continue
time.
for some more time.
So, my Lord, may I come back on the next day? I'll
Please,
continue on the
we
next.
need to continue to call to 4. Any Lordship will
No,
raise-
the court will
3:30.
write the
My learned
3:30.
senior friend perhaps has not been instructed.
No, I've been instructed. Don't consider instruction.
My Lord, may I come back on the next day? I'll come back so that, my Lord,
Because the court will rise at 3:30.
Lordship.
Let him continue, but today your Lordship will not take up any other matters.
No, I don't think that has fallen from your Lordship.
See, first of all, Mr. Bagh will not be able to conclude. So,
24th.
when he is unable to utilize this time, it's better to share it with somebody else. With his learned friend.
Utilize this time, my Lord. He will utilize this time by trying to finish. The
No,
matter.
that he cannot.
I'm not saying he will finish today, but let him continue before another fresh matter is
Yes,
taken up.
because if I cannot complete, what is the use of continuing?
No, but
Hardly you'll have 20 more minutes.
he will take some. He will advance the matter.
Yes. How long will you take on the next day?
My lord, I'll take the next day in entirety, my lord.
Entire day will take.
My lord, I will. Second half, I'm expecting if it's a Friday, my lord, it'll be that 3:30. So with that, I think I'll get 1.5 hours to, my lord, argue.
Yes, record an order. Learned.
Thereafter, my lord, I will make my arguments in my, my lord, affidavit.
अच्छा आगे जे अच्छा Mr.
I
Bagh.
want the same point that the company's properties cannot be partitioned. That is the point. And then the other point is that
I'll summarize my points, my lord. I'll indicate my
no. He will summarize. Of course, he will summarize. He, Mr. Bagh, he will summarize his points. But I'm saying, what are the points? That the company is different juristic entity. The properties cannot be partitioned. Arguably, already argued by Abhijit Mitro. Company's properties cannot be partitioned.
Anyway, you see, if it is a
Whatever
matter
I'll
of,
argue, my lord, I
if it
think
is a
should not be
repetition,
preempted.
no, if it is a repetition of
It will
the
not be a
other
repetition.
points,
It will not be. I'll
It
indicate
is a
my own
repetition, and then for third
how
the
this is
NCLT
absolutely not maintainable. I'll make out my case.
Mr. Bagh submits but could not conclude his submissions. Let this matter appear on 24/4/2026. Just a minute. 16/4/2026.
But may I humbly pray, my lord, if it is taken up on the next week, 24th, my lord. 16th, I'm in some difficulty. 17th, my lord.
17th, this bench may not sit.
Then kindly take it up, my lord, on 24th.
16th is Thursday, my lord.
Thursday, my lord.
But on 17th, this bench may not sit. That is why I wanted to proceed on 16th.
Let it be 16, my lord. There should some urgency. They want my plane to be dismissed after 13 years.
13 years, another week, I don't think will make a difference.
Okay, 24/4/2026.
No. He wants the plane to be dismissed.
Not he. He is supporting that person who wants it to be dismissed.
And he is a director. He's a company, and the person who's made the application for
So let
is
me
a
see his
director.
bona fide. Let me see his bona fide.
What is the bona fide, my lord? The director makes the application, and the company's office is a director. Kindly keep it on the 16th, my lord. Kindly keep it on the 16th. Let him.
Thursday, I have some other
Well, we'll come back on 24th.
Anyway, for some matters I've already fixed. So it is better to keep it on Friday.
We'll come back on
because it will take time.
Lordship.
Because on 16th, my lord, that contempt application is also, my lord, there, my lord, which your lordship has
Some
taken.
other appellate side matters are there. Just because I'm not sitting on 17th, that is why I kept some matters on 16th.
We'll come back on 24th. My lord. Very deeply.
Okay.
Obliged. Very deeply.
Great.
Let him try to finish on the 20th. He says he'll finish on 24th, my lord, but let him finish.
Anyway, I shall see on the next day.
Unless your lordship pushes a bit, my lord. Lordship will have to push a bit.
Okay, I shall see on the next day.
And my lord, when he is repeating what Mr. Abhijit Mitra has already submitted, that, my lord, your lordship knows. Companies' properties cannot be partitioned corporate entities, and I've got decisions. With the family property, it can be done.
Because at the end of the arguments, all of you have to submit written notes.
End of the argument, let them submit written notes.
Yes. All these things will be considered.
All these.
Okay. Yes.
Your lordship will just consider my plane.
Yes. Whatever I have to consider as per law, I shall consider.
My plane, whether or not a cause of action has been made out. I don't have to succeed. My plane may be dismissed in the later stages. But that doesn't mean in Order 7, Rule 11, it will be chopped off. That is the Order 14, my lord, quantum maintainability can always be considered. Mr. Deb has submitted Order 14, Rule 2, that quantum maintainability of the suit can be an issue which can be raised.
Let us proceed, okay?
Yes.
We have started proceeding.
That is good.
We could not proceed for a long period. We have started proceeding.
This is good.
Definitely.
A good sign, good omen.
Yes. Definitely we will reach our object.
Yes, very good.
Okay. Thank you.
I'm grateful to your lordship.
Yes, call 7.
I'm grateful, my lord. My lord, my suit for, my lord, specific performance. My lord,
Mr. Bose is appearing.
Mr. Bose is leading me in this matter, my lord. Mr. Bose is leading me
Yes,
in this
now
matter.
this matter, the report is to come, no?
Yes, my lord. The
Which for the
report is,
state or the state government?
yes.
The registrar?
Mr. Banerjee was appearing on the last occasion, my lord.
Okay, let me see the report.
But I believe, my lord, the report will take some time because of the intervening elections and, my lord, the SIR, my lord,
Just a minute.
process. Perhaps, my lord, the report is taking some time. But we also want to, my lord, do the matter because, my lord, it's, my lord, we are the plaintiff, my lord, we are suffering every day. But, my lord, even despite, my lord, our diligent and best efforts, my lord, we cannot get, my lord, the report. And, my lord, this situation is such, my lord, we cannot pressurize, my lord, the state also to, my lord,
Okay, this is 19/3/2026.
Yes.
Okay, this is the letter. 26. It last.
Well, the last communication we received is 24th of February 2026.
2026.
Oh, this we do not have. This we do not have. এটা অবধি আমি জানি 19/3/26 টা জানি কিছু এসছে নাকি আমাদের কাছে কি দিচ্ছে
No, today anybody is representing.
No, no one is there for the state, Mulad.
They have stated it will take some time. Anyway, it's better to keep it in the middle of May. In the meantime, one more reminder.
Post election, Mulad.
Yes, it's better to give one more reminder, and I shall request the learned.
Post vacation ta onek late hoye jabe. Mulad, yes, Mulad.
Middle of reminder and one more intimation to the state government advocate who has appeared on the last occasion.
Kindly provides that, Mulad. We'll do that.
Okay.
Mr. Paritosh Sinha.
Learned advocate for the plaintiff and learned advocate for the defendant are present. Although on the last occasion, on 27th February 2026, learned advocate represented the collector. However, today none appears for the collector. Stop. The collector, by letter dated 19/3/2026, addressed to the Section Officer High Court Calcutta original side, has intimated that the matter requires some time as large quantity of old records is required. In the facts and circumstances, the matter stands adjourned till 8/5.
Well, can it be the week thereafter?
15/5/2026. Let a copy of this order be communicated by the department to the collector, and a copy be communicated by learned advocates for the parties to the said authority, as well as to the learned advocate Mr. Oyon Banerjee and
Mr. Paritosh Sinha. Mr. Paritosh Sinha.
Learned advocate Mr. Paritosh Sinha. Mr. Oyon Banerjee also appeared on the last occasion.
But Mr. Paritosh Sinha acts as the instructing advocate.
So,
a copy of the letter may be circulated to the parties as well. This 19th March letter. 19/3
a copy of the letter addressed by the collector of Kolkata Stamp and Revenue to the Section Officer High Court Calcutta, dated 19/3/2026, be supplied by the department to the learned advocates.
I'm grateful.
So you communicate.
Yes.
The department will also communicate, and you communicate to Mr. Sinha also.
I'll do that. I'm grateful.
আরেকটা line লিখে নেবেন তো। Mr. Sinha, learned advocate, is also requested to look into the matter so that it is expedited.
I'm grateful. Deeply.